Delivery of order. Item number 1.
For reasons mentioned in this order, the interlocutory application is allowed. The impugned judgment and decree dated 5/1/2026 passed by the Court of Learned Civil Justice Senior Division number 3 in title suit number 1/2009 is hereby stayed during the pendency of the connected regular first appeal, subject to payment of an amount of payment of a sum of rupees 15,44,000 by the applicants before the registry of this court within a period of 2 weeks from the date of this order.
Period may be extended, my lord. That period, my lord, may be extended, my lord.
You-
1 week, one month maybe.
No, you file an application.
Much of that.
May it please, my lord. Prayer seeking upgradation in item 68, my lord. There is some urgency in the matter, my lord. 68, my lord. My lord, there is a FAO application, my lord.
Mhm.
There is some urgency, my lord. And
What urgency?
my lord, the urgency is that, my lord, the honorable court below did not grant us ad interim injunction, my lord. This case pertains to a notice which has been issued by the bank, my lord, regarding taking possession of the property, my lord. Whereas we were not the
Who is for the other side?
other side, my lord, bank is there, my lord, Bank of Baroda and 2 private respondents, my lord. I have done dusty service upon them on the last 25th. It is a part of the records also, my lord. I've served copy to them
Upgraded
at 2 o'clock, my lord.
at 4 p.m.
4 p.m., my lord.
Okay.
Deeply obliged.
Yes, please, your lordship. Lordship, I beg to mention for listing, lordship. Lordship, MSC April 235/2021, lordship. If it possible, lordship,
Yes,
April,
put up. Orders column.
no, lordship, hearing.
Orders column. 24th April.
Please, your lordship. Lordship, I beg to mention item number 31. I'm appearing on behalf of A.K. Gupta, lordship. Lordship, let me
Yes.
come after vacation, leave vacation.
You have informed the other side.
Yes, lordship. I'm for the respondent.
Heard miss. Heard miss. What is your name?
B.S. Ojha.
B.S. Ojha, Learned Counsel, appearing on behalf of Mr. A.K. Gupta, Learned Counsel for the respondent, has prayed for an adjournment. She submits that she has informed Learned Counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, this prayer is allowed. Let this 27th of April.
Obliged.
Wait, please, your lordship. Lordship, I beg to mention for listing of MSc appeal for orders.
24th.
24th, obliged.
Wait, please, your lordship. My lord, I beg to mention listing of a MFA, my lord. It was previously
Which
listed but
column?
deferred. My lord.
Which
In hearing column, my lord, it was a part heard matter previously.
part heard?
Yes, my lord. Previously, it was once part heard. And
No, it was. Is it shown as part heard in the order?
currently, it's not showing in the cause list, but previously it was part heard, my lord. And I have urgency in this matter. Can it be listed in April?
No, April we don't have any dates. 11 June.
Any prior date, my lord. There is certain urgency in my matter. I am praying for a contempt proceeding against the member of the tribunal, my lord, in this matter.
You can go for contempt proceeding. There is no bar. If there is no stay, you can.
There are certain other urgencies as well, my lord.
What?
My lord, the matter pertains to terminal charges, and every day
This
the
is-
claims are being repudiated, and it will lead to endless litigation, my lord. Lots of litigation it will lead to.
No, 11 June.
Much obliged.
May it please, your lordship. Lordship, with regards to item number 57 and 58, we had filed a delay condonation, but it has not been listed today. So
The lordship may kindly call for it along with the subsequent IIs listed today.
Yes, call for the ayes.
Much appreciated.
For withdrawal, item 55 and 56.
Your Lordship, we wish to withdraw this MFAs, Your Lordship.
Miss A. Biani, learned counsel for the appellant, who prays for allowing the appellant to withdraw the instant appeals. The prayer is allowed. These appeals are dismissed on withdrawal.
Most obliged.
Bail hearing be item 11.
Lordship, I was supposed to ask another PPP Lordship, P Locker, was supposed to ask Lordship about the 36. Under section 36 Lordship. And I have also informed by him Lordship, due to election duty, police has not been able to communicate. And I want to again want to draw court's attention Lordship to an order sheet Lordship. এইটো দেখাই দিয়কচোন। It was 36 will live. What you may kindly in the first few lines, Lord. We stated that it has been given, Lord. The petitioner is the same, Lord.
No, what is your plea? What is your submission?
My lord, yes, 6 person has been arrested and they are
In your case, there is no arrest memo.
no arrest.
Oh, no, you were asked to take information from the IO.
Lordship, I have not been able to because of election duty. They are not able to communicate, Lordship. If possible, Lordship may give us time, Lordship. Day after yesterday, day after tomorrow, Lordship. If possible, Lordship. I apologize for that, Lordship.
Okay, let them find out. Heard, Mr. HR.
Ahmed.
H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that this case was earlier dealt with by another additional public prosecutor, namely P.S. Locker. He submits that as the police is busy in ensuing election duty, he could not obtain the necessary information regarding the query posed by this court on 25/3/2026. He prays for a short adjournment so that he may take the necessary information from the investigating officer. The prayer is allowed. Let this matter be listed. 20.
This month, 25, 23. No,
27th or আগত দিও।
30, এটা আগতে দিব লাগে।
আগত,
No,
আগত।
দি দিও। আগত দি দিও। Okay.
After election,
After election.
20 April,
Lord.
20 April.
Much obliged.
Admission, item 2.
Lordship, this is a matrimonial appeal, statutory appeal. This is against an order passed under section 26 for custody of the child, Your Lordship. Custody was denied to the respondents. However, visitation right was given 3 days a week, 3 hours per day, Your Lordship, and Sunday for the whole day. The child is presently 5 years old, Your Lordship. On 3 days a week, that is the ground, Your Lordship.
Your mother,
And the mother. the father takes, if the father takes during 3 hours, the school of the child is getting hampered, your lordship.
Yes.
And
He is from the Sunday, but till today, my landed friend cannot say that a single day visitation was allowed. They have flouted the order of the landed court
Where the parties stay?
lordship,
at
Chirang district. Your
Chirang district.
Lordship, that apart, there is another case which is listed today at item number 27. That is against the order of restitution of conjugal rights, your lordship. They have
That is a different matter.
That is a different matter between the same parties, your lordship. The husband has prayed for restitution. I have prayed for divorce, your lordship. The divorce case is pending and the restitution was allowed. And this order for custody was also disposed of. Against both these, two matrimonial appeals were filed.
No, whether in this matrimonial appeal, records would be necessary.
No, they have not allowed me to visit, to meet my child mother till today.
In this,
Not a single day they have come. She is
on
willfully
Sundays,
denying the order of the court.
You at least allow on Sundays.
I have instruction that she is allowing on Sundays, your lordship.
Every Sunday. Yes, every Sunday,
That
3
can
hours.
be done. That can be recorded.
No, my lord. No, my lord. It may not be. At this moment, if your lordship will change it, my lord, their petition will be amount to allowed, my lord. That is the problem. Now, my lord, visitation that was Tuesday, Thursday.
Now, what
3
do you
hours.
want?
Pardon?
What do you want?
My lord, at least they must. Why they have not complied with the order of the court, in spite of the fact that there was a stay order from the honorable court. I am father, my lord. I have got every right to see my son. And I have been deprived. She is not living with me because she got a very good job, high ranking. That is the cause of deprivation.
Okay, we will admit this appeal.
No, it is not a Tuesday, Thursday, 3 hours, Sunday, 10 a.m. to 4 p.m.
We'll admit this appeal, call for the scanned copy of the records and hear the matter on the next day.
In the evidence, they
And-
should comply with the order of the court below.
Sundays, I have no.
No, not
but-
Sunday, any Tuesday, Thursday. It is 3 hours. Means after, let them come at 5 p.m. 5 p.m. Let it be
No.
2 hours.
No such. Whether
all-
will it be possible for the parties to come to before this court in person, both?
Yes, I can bring both of them. Yes,
Then let them come before this court.
Mediation.
yes.
Heard. Mr. B.J. Mukherjee, learned counsel for the appellant.
For the respondent, lordship, I am filing my affidavit today, lordship.
My lord, let the matter be admitted. My lord, earlier also taken.
TCR has
It
not
is-
been received, lord.
Let me
Has
submit.
TCR been
I am
received?
the appellant. I am the appellant, my lord, because this is testamentary appeal, my lord. And the first day they have till they will submit counter affidavit, my lord, with evidence. But till that 1 month, my lord, they have failed to submit, my
We
lord.
are filing it today, lordship.
No, where is the question of filing affidavit in appeals?
Because lordship, some facts are there which are not clear, lordship. That is why I want to bring it on record, lordship.
No, then there is a procedure in appeal. If you want to bring additional evidence,
Not
additional matters,
Not,
Yes, my-
it cannot be by way of affidavit unless an application under order 41 rule 27 is filed.
lordship. We are filing that also, lordship.
We are admitting this. We are giving you time. Heard Mr. S. Saikia, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned counsel for the caveated respondent. This appeal under section 299 of the Indian Succession Act 1925 has been preferred by the appellant Shri Uttam Deb, impugning the judgment and decree dated 17/10/2025 passed by the Court of Learned District Judge Kamrup Metro in probate title suit number 6/2018, whereby the probate application filed by the present respondent was allowed. I have gone through the grounds stated in the memo of appeal and had learned and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of probate title suit number 6/2018 be called for. The appellant, the registry shall take steps for requisitioning the aforesaid records. Since Mr. A. Bhattacharya has already appeared for the respondent, for the sole respondent, no formal notice need to be issued to the respondent. Learned counsel for the respondent also prays for allowing the respondent to file an appropriate application for bringing on record certain materials relevant for consideration of this appeal. The respondent may do so before the next date fixed. Let this matter be listed on 20th of May.
Much lordship, much lordship.
Item four.
My lord, I will take your lordships to office note dated 26/3. It has been shown to be insufficient address.
Insufficient address.
Now, my lord, I will take your lordship to page 57, the plaint, their plaint. My lord. Exactly, we have borrowed from there itself. Same address. my lord.
So what is to be done?
Lord, the address remains to be correct one. In such a circumstances, my
No.
lord, it appears they are avoiding it.
How can you say that the address given by them in their plaint is correct one? That may also be insufficient.
That, yes, of course, that way if we think, of course, but then knowingly, my lord, they are not supposed to give a incorrect address.
Yes, but if you believe the postal endorsement, it appears that
Otherwise, my lord, if your lordship look into that, it's remain the same address. My lord, in that
now what is
event,
your submission?
my lord, in that event, my lord, since the endorsement is something else, and then we can fall back order 5 rule 20.
Newspaper publication.
My-
Okay,
That is the only way out.
okay. Heard Mr. S. Datta, learned senior counsel assisted by Mr. A. Bishwas, learned counsel for the appellant. It appears from office note dated 26/3/2026 that the notice issued to respondent, sole respondent by speed post has returned with a postal endorsement within inverted comma insufficient address. Learned senior counsel for the appellant, by referring to the copy of plaint which is annexed along with the memo of appeal, has pointed out that the address of the respondent given in the plaint filed by them before the trial court is the address in which the notice was sent. And in view of the said address being found insufficient as per the postal endorsed remark, he submits that the appellant may be allowed to take steps for issuance of notice upon the respondent by substituted mode of publishing the notice in newspapers. The prayer is allowed.
My lord, in Assam Tribune.
Assam Tribune, Howrah.
Oh, sorry. Yes, yes. But then, my lord, having his registered office at Hizuguri, Tinshukia town. And one of its director at, that is of course at Howrah.
You, at which address you have taken steps?
Tinshukia town, my lord.
In Sukia.
Or my lord, we can do one thing, throw registered post to this Howrah address also we can take by speed post.
You
In-
take steps again
Yeah.
on both the addresses
both
once,
addresses.
once more.
Throw, my lord, speed post.
Stop. Newspapers. I have considered the submissions made by learned senior counsel for the appellant. It appears on perusal of the copy of plaint annexed along with the memo of appeal that the respondent has two addresses shown in the copy of plaint, one at Tinsukia and another at Howrah. Stop. This court deems it proper to direct the appellant to take fresh steps again at both the addresses of the respondent by speed post within 7 days from the date of this order, returnable on 20th of May, list accordingly.
My lord, interim order may continue.
The interim order shall continue till next day.
Obliged.
Item 5.
Please, your lordship. Lordship, the fact of the case is this, lordship, the present respondent filed a title suit for declaration of right title interest, recovery of possession, lordship. And that suit was decreed. Thereafter, the decree was put to execution. But in that suit, your honor, or execution proceeding, the present petitioner appellant was not a party. He was not one of the defendants. But he was in possession of a plot of land measuring 2 kathas, your honor, by constructing houses, your honor, by dint of an agreement to sell, lordship, executed by the plaintiff through their attorney, your honor. So when when the petitioner appellant was evicted, lordship, the petitioner filed an application under order 29 rule 99 reduced 101, rule 101, lordship. And after hearing the parties, my lord, my petition was rejected. Then I filed the appeal before the Honorable District Judge, Kamrup Metro, lordship. And along with a injunction. In the meantime, what happened during the pendency of the appeal before the Honorable District Judge, lordship, the respondent has started construction of the RCC building, your lordship. Then I filed it.
Over your land also. You said
Yes,
that.
yes. And lordship, then I filed an application, injunction application under order 39 rule 1 and 2. The learned appellate court did not grant the injunction, against which this power has been filed.
Okay. Okay.
And my learned friend, when appearing in the appeal and the interlocutory application, already submitted that the respondent has not done anything. It nearby public was throwing the garbages over the land. That's why GMC has erected 4-side CI6 boundary.
Oh, yes, yes.
Then lordship, this honorable court directed me to take the photographs of the suit line. I have filed, those photographs was taken, and I have filed along with my additional affidavit, lordship, who shows that in large scale, the construction is going on, lordship. Your lordship, may please to take up the additional affidavit
In IA.
In Ireland.
No. What has happened to the the appeal,
Appeal is pending, Lordship.
no present appeal.
Present appeal is pending. Lordship, during the pendency of the appeal, the respondent has started the construction over the 2 kathas of land, Lordship.
No, whether present appeal has been admitted or not. This appeal, this,
No, not admitted.
we'll admit it.
Because 4 times my learned friend has taken the adjournment.
Whether the interlocutory application, any relief has been granted in this case.
No, Lordship, because your Lordship, I was directed to file an additional affidavit annexing the photographs of the suit land.
Now my query is whether should we dispose of the appeal itself or
It can be disposed of, Lordship. It can be disposed of. Because Lordship, if you're.
whether appeal can be disposed of.
Appeal
Because
and I
appeal is pending, your Lordship. Not the
Okay, no, should we dispose of this appeal?
Lordship.
Okay.
Because title appeal,
Okay,
title appeal is pending. In the, before the appellate court, they file
Okay.
an application.
Yes, Mr. Roy, make your
Yes.
submission.
Then Lordship, will please to take up the additional affidavit filed by me, Lordship, on 25 to 26.
In the interlocutory application.
In the interlocutory application, number Lordship 508. I suffered the same thing. Lordship, may be pleased to come to page 41.
Yes. Yes.
Page 41, Lordship, see the photograph. RCC pillars, rod, TMT rods are seen clearly, Lordship, over the suit line. Then the next page 42, your Lordship, is the huge.
No, over how much area the execution proceeding is going on?
Proceeding was,
In respect of how much,
it was a big plot of land.
How
but
much?
My case is confined only to 2 kathas.
your case is you are possessing a land measuring 2 kathas.
Yes.
2 kathas and
2
only
kathas
only 2 kathas. Out of the suit land, what is the area of the suit land?
Area of the suit land is Lordship. It is a big plot, Lordship.
Lordship, it is 6 bighas and all.
The decree was passed in
In
respect
respect
of
of entire 6 bighas of land.
6 bigha.
2
And-
bighas,
6 bigger, 2 kathas, 9.
6 bighas, 2 kathas, 9 lakhs.
And out of these 6 bigha, you have 2 kathas.
My claim is only limited.
It is identifiable which
A specific boundary has been given.
over 2 kathas of land.
Yes, yes, north, south, east, west.
Now, whether construction is going on over your plot of land,
Yes, I have taken the photographs of my plot.
okay.
Because Lordship, respondent in their objection taken the plea that they had not started the construction. It was CI seats were erected on the 4 sides of the suit line on the complaint of the public workfare and which were erected by the GMC, Lordship, which is not correct, Lordship. The pictures show. Then your Lordship directed me to take the photographs of the suit line measuring 2 kathas and file it by filing additional affidavit, which I have done. Now,
The appellate court is the court of district judge,
yes, Lord.
which
This is a
There
common.
also interlocutory application
There
is
also,
pending.
Lordship, first of all, appeal was filed.
In
And
that appeal, you filed an interlocutory application under Order 39, Rule 1 and 2. Is it disposed of or is it pending?
so cause notice was only issued.
And what was the next date given in that case?
Next date, Lordship,
6-4.
6/4.
What is the stage?
It stays.
Have you filed any written objection in that?
We filed a written objection because we did respondent there. They
Okay.
filed the application and the interim order, your lordship, at page, which has been challenged before this lordship, at page lordship 122 of the memo of appeal.
You found it.
Okay, let me hear him first. Yes.
So Lordship, the photograph clearly shows that the respondent is proceeding with the construction, Lordship. But they had when the first day in the matter was moved, my learned friend has submitted that the respondent is not doing any construction. And in the affidavit in opposition, Lordship objection also, they have stated they are not doing.
Yes, anything else?
There was a similar case, Lordship. The Honorable Justice Devashish Borua passed the order directing to maintain a status quo. And in the status quo order passed by this Honorable Court, it remained in force till the disposal of the injunction.
Okay. That cannot be a precedent in this case.
The similar situation, Lordship. Only in that also only so-called was notice was issued. Then I filed the file along with injunction. So injunction was granted, directing both parties to maintain a status quo till the disposal of the injunction.
Can this be a precedence?
No, Lordship, just
Okay. Yes, anything else?
no, Lordship, may be pleased to consider if the status quo order is not granted, Lordship, I will be compelled to face the multifarious proceeding because the respondent has started the construction of the RCC building. So after completion of the construction, it will be letter to the tenant, Lordship. So my appeal will become infructuous before the district. And it is well settled law, Lordship, if there is a dispute regarding the position, Lordship, the suit line should be, a status quo order should be passed.
No, what you want to show by these photographs?
Photograph shows, yeah, Lordship, they have started, respondent has started construction, Lordship.
Which photograph?
Yeah. Additional affidavit filed by me, Lordship.
Yes, which one? At page 41, there are 4 photographs.
There are 4 photographs, Lordship, and the bottom right side photo shows the RCC pillars have been already erected, Lordship. And next page, your Lordship, will the huge quantity of TMT rods have been stored over the shoot line, page 42, Lordship. All building materials have been collected, Lordship. And Lordship, page 43 also shows that the bamboos, all these things have been small houses. And for accommodation, page 44, Lordship, for the accommodations of the laborers and the mistri, one temporary house has been already constructed, Lordship, over the shoot line. And your Lordship will see page 44A, Lordship, shows the building materials, Lordship, TMT rods, collection of rods. Then page 45, your huge collection of the TMT rods, Lordship. Huge collection of TMT. Then page 45A also shows the storing of the TMT rods and other building materials, Lordship. On the first day of the moving the petition, lordship, my learned friend has submitted that no construction is being done by the respondent. We are also having the video.
You have given a pen drive also,
Yes, yes.
showing what?
Video, construction stage. It may be played, lordship.
Yes, Mr. Goyal. They are seeking status quo only till 4th.
Lordship.
Do
Now-
you have any objection?
Lordship, one thing, because they preferred an appeal, your lordship, against an order passed by the learned district judge, being an appellate court. So for the application is concerned, filed before the learned district judge, what wrong has been committed?
Where is the impugn order?
122, your lordship, of memo of appeal. The next are 10. Because lordship is to interfere the order. Relevant portion, lordship, at page 123, paragraph number 6. Lordship got it.
Yes.
Copy of the petition has been furnished to the learned counsel of the opposite party. Opposite thus, the learned counsel prayed for time for submitting written objection. As the opposite party, Ajit Das, has appeared through his engaged counsel, issuance of notice is dispensed with. I have heard the learned counsel of both the sides and also carefully perused the contents of the petition filed by the petitioner. I am of the view that the opposite party should be given a reasonable opportunity to file his written objection. No interim order is passed at this stage, because that has been filed in an appeal of the year 2018, which not yet been admitted by the learned appellate court because appeal was filed at a time bar. So at that stage, the learned appellate court considered the application and given an opportunity to the opposite party to submit objection. We filed this objection. What wrong has been committed? Now, what is to be interfered by the honorable court?
My case is entirely different, lordship.
Lordship.
During the pendency of the appeal, the respondent has started the construction, lordship.
Lordship,
And lordship,
2013, 9 SCC, 221. Paragraph has been mismatched. Even then, paragraph number 15, your lordship. Given flag marks. In a situation where the learned trial court, on a consideration of the respective cases of the parties and the documents laid before, it was of the view that the entitlement of the plaintiffs to an order of interim mandatory injunction was in a serious doubt, the appellate court could not have interfered with the exercise of discretion by the learned trial judge unless such exercise was found to be palpably incorrect or untenable. Next, lordship, it should have been 16, but it is numbered as 14.
Yes.
The appeals before the division bench were against the exercise of discretion by the single judge. In such appeal, the appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the subtle principle of law regulating grant or refusal of interlocutory injunction. So, the principle has been laid down by the Honorable Apex Court when it is to be interpreted. So, for our case is concerned, your lordship, so what a non-impugn order is concerned, what wrong has been committed? only opportunity was given to the respondent to file the objection. We submitted the objection. And one thing they have committed, what happened? They given a wrong schedule. So the amendment application has been filed before the learned trial court.
Trial court or the first appeal?
First appeal, sorry, first appellate court. First appellate court. Their schedule was wrong. And when we raised this plea, they filed an amendment application for amendment of the schedule that is pending before the first appellate court. Now, Your Lordship, so for the photograph is concerned, Lordship, in my affidavit on objection, I have submitted everything. This opposite party, he was constructing the building of Amingao Sessions Court, District and Sessions Court. So some wastage materials were kept there. When the opposite party was directed to remove the same, he brought it and keep it in the said premises because it is his own land. It is their land. They are not going to construct anything because from photograph it reveals my learned senior brother has submitted that they have erected, the opposite party erected a concrete post where from it is seen. I have not seen it. And all the photographs says it is a used materials. Used materials in paragraph number 40, page 42. All are used materials. It was brought from the Amingao court and it was kept in its place, which was vacant. And in our affidavit, Lordship, we have in initial objection in 508, we have given the photographs. What was going on in respect of civil problem? All the people, neighboring people, they are dumping, used as a dumping ground. So that is why from neighboring their complaint,
Throwing garbage.
also throwing the garbage. So that is why GMC asked us. Now, we cannot put a chokidar, Your Lordship. That is why some tin boundary has been given so that nobody can throw out the garbage. That was the position, Your Lordship. It is we got the decree, Your Lordship, 1991. And they filed the appeal in the year 2018.
No, they have filed appeal against the order of rejection.
By the learned
Executing court in
Lordship.
order
It is in the year 2018.
that order was passed in 2018. And is there any delay condonation application
Yes, Lordship,
pending?
prison is there.
Pending.
Pending.
Lordship, it is.
How the decree holder has been frustrated, Your Lordship. I am not going to make any construction.
Then what prejudice will be caused?
Definitely.
If my learned friend is submitting, he is
Because
not going to do any
Lordship, in
construction.
disposing of the
But he will not suffer
Section 5
any
application
loss
from
and
5 years
injury.
left. And if the injunction has been granted, and again they will delete the matter.
Okay. Heard. Anything?
Lordship.
Heard Mr. S.P. Roy, learned counsel for the appellant. Also heard.
Not passed by the decision. They don't discuss at all 3 golden principles of the injunction. Impugned order is without divide of any regions, Lordship.
Also heard Mr. R.K. Bhuya, learned counsel for the appellant. This appeal under order 43 rule 1 within bracket R of the Code of Civil Procedure has been preferred by the appellant Shri Binod Hajurika, impugning the order dated 11/2/2026 passed in Ms. J case number 7/2026 arising out of title appeal number 31/2018 by the Court of London District Judge, Kamrup Metro, whereby the appellate court issued whereby the appellate court refused to grant an ex parte ad interim injunction and fix the matter for filing written objection by the opposite party on 24/2/2026. Stop. The facts relevant for consideration of the instant appeal, in brief, are that when is the next date fixed?
6/4.
6/4. Let this case be listed for delivery of orders tomorrow. Tomorrow I'll pass orders. Not so and so. Delivery of orders tomorrow, that is 31/3.
Obliged.
Yeah.
Six.
Yes.
May I please, Lordship? Lordship, here the present appellant's petitioner's Lordship filed a title suit, Lordship, before the civil judge, Senior Division Lordship, Murigo. The fact of the case is this, Lordship, the private respondent Lordship, they are the owners of a plot of land, which was taken on lease in pursuance to a lease deed, Lordship. That is the Annexion number 4, page 30, Your Honor, dated on 19/12/16, Lordship, which lease is valid up to 2031. That your lease deed, Your Lordship, will get at page 30 of the IA, Lordship.
No, just a minute. Yes, you repeat again. Oh, I missed out.
Lordship, the respondent, they are the owners of a plot of land measuring almost more than 4 katas, Lordship.
Respondents.
Respondent, Lordship.
Okay.
They are both, the parties are brothers, Lordship. The petitioner appellant is the brother of the respondents are the own brothers, Lordship. And petitioner is also one of the brother, Lordship. Petitioner or appellant, Lordship. Then, Lordship, for the present appellant, Lordship, they are doing the business of running the petrol pumps, Lordship. So the petitioner has approached his brother's respondent, Lordship, and a deed of lease was executed on 19/12/16, by which the land was leased out to the present petitioner, Lordship, which lease deed is valid up to 2031, Lordship. That your lease deed, Your Lordship, will find at page 30 of the IA, Lordship.
We're valid up to how?
2030. 31, sorry. That lease deed is as page 30, Lordship.
Yes, there are.
Annexure 4. annexed for lordship. I have annexed the vernacular as well as the translated copy of the lease. Vernacular, your lordship will find at page 34, lordship. It is in Assamese for a period of valid up to 2031. Lordship will find that the lease period.
Page 34 is
34 is the lordship, the vernacular agreement, original. I.
in IA. Yes.
So page 30 is the translated copy, translated from Assamese vernacular. Vernacular lease deed is lordship, page 34. This is dated 19/4/2016.
Yes.
And your lordship will find that next page, lordship 35. Page 35, clause number 2. Ukta matir মেয়াদ 15 বছর পুনৰ চুক্তিনামা সম্পাদন কৰিব লাগিব. So even after expiry of the earlier 15 years, which will expire in 2030 or another, the lessor was bound to extend it, lordship, because the appellant petitioners are running a petrol depot about the land, lordship. And then, lordship, what happened in the meantime, the respondent filed a writ petition before this honorable court, asking that, falsely submitting that the lease period had expired, so the IOCL may be directed to remove its machineries, vending machines, your lordship. Accordingly, the honorable court and no notices of the writ petition was served to the present petitioner appellant, your honor.
It is WPC number?
Lordship.
What is the writ petition number?
Writ petition, lordship. 4499, lordship. Of 20.
Page 99.
Page 99, lordship. I have annexed.
Okay. Thereafter?
Thereafter, lordship, by suppressing the lease deed of 16/4/1916, your honor, 19/4/16, the writ petition was filed, an order was passed by this honorable court directing the Indian Oil Corporation to remove the machine and the other structures from the landlordship. And lordship, thereafter, on 10th of February, lordship, respondent had come to the suit land, my own brother's lordship, and tried to evict me forcibly and illegally. So under that compulsion, I filed a suit, lordship, for my protection of my possession, lordship. But the learned trial court, after hearing at length, I had personally moved the matter going to Modinga, lordship. The learned trial court refused to grant the ex parte injunction, lordship. And the only so-called notice was given without discussing three golden principles of the injunction.
When is the next date?
Next date. Right. Now the date has been
22nd May.
now next date is fixed on 22nd of May 26
Filing of objection.
for filing of objection by the respondent. On the first date of appearance, respondent did not appear, in spite of service of the summons and the notices.
Who is in the possession of?
And now we are in.
You are still running a petrol pump there.
No, I am in position. Petrol depot has been closed. We are not selling the fuels.
Okay.
In the plain lordship, I had made a specific averment that the defendant, that is respondent, had come to the suit land, your lordship, on 10th of February and tried to evict the appellant petitioner. that your lordship will get at memo appeal, page 23, lordship. Memo appeal, page 23, para number 26. Page 23, para number 26. Para 26, lordship, that on 10/2/2006, the defendants along with their men came to the suit premises and tried to dispossess the plaintiff using muscle power, but somehow the plaintiff defended themselves and accordingly protected their possession over the suit land for the time being. So this was the urgency, Your Honor. That's why the suit was filed, lordship, along with the injunction application.
Where is the impugned order?
Impugned order, lordship. Page 43 of the memo appeal. Totally non-speaking, non-reason order, lordship. Page 43, lordship.
Where is your injunction application?
Injunction application, lordship. Annexure 2, lordship. Page 28. It's my characteristic.
Where is your prayer for ex parte injunction?
Period starts from lordship, from page 40. Here also specific abatements are there that the respondent defendant tried to evict the petitioner appellant on 10th of February 26.
No, where is your prayer that by dispensing with the notice?
Yes, that your lordship. Page 40, lordship. Yeah. Lordship, para 32, page, that the object of granting, page 40, page para.
The appeal is yet to be admitted, this appeal?
Yes, lordship.
Okay, heard Mr. S.P. Roy in appeal. Heard Mr. S.P. Roy, learned counsel for the appellant. This appeal under order 43 rule 1 within bracket small r of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the order dated 16/2/2026 passed by the Court of Learned Civil Judge Senior Division, Morigaon in Miss J case number 20/2026 arising out of title suit number 11/2026 whereby the trial court issued notice to the respondents and refused to grant any ex parte ad interim injunction. Stop. Learned counsel for the issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd of May. No, when is the date fixed in the
No, 22nd May 26. Such a long date has been given.
returnable on before 22nd. On 20 May. List accordingly. In interlocutory application, this interlocutory application has been filed by the applicants under Order 39, Rule 1 and 2 of the Code of Civil Procedure, read with Section 151 of the said code, in connection with the connected first appeal against order number 15/2026, praying for grant of temporary injunction against the respondents from interfering with the from dispossessing the present petitioner during the pendency of the present appeal, and also for restraining the respondents from alienating the sued property to any third party during the pendency of this appeal. Pendency of the connected appeal. Stop. Learned counsel for the respondent has submitted that, and learned counsel for the appellant has submitted that, applicant has submitted that the present applicants and the respondents. Who is brother?
All are.
Dependent number one is the
Dependent number
one is the brother
one
and 2 to 5 are the legal heirs of.
and 2 to 5 are the legal heirs of the deceased brother number Girindas.
Are relatives. Defendant number.
One is the brother lordship and 2, 3, 4, 5, they are the legal heirs of late Girindas. Girindas and Ashok Das and the present appellant lordship, they are all brothers.
No, the appellant number one is a lady.
Sorry, Osmi is the brother's wife. Mosumika. I wrongly said.
She is the sister.
Sister-in-law.
Number 2 is the.
She is the wife of your lordship Parasmani Das, who is the own brother of the respondent, number 1. And also the own brother of late Girindas.
These holders may mostly commonly party.
The lease deed was entered into between whom?
Between lordship be paid, lordship be pleased to payroll. Page 30 of the How lordship. Sorry, page 30, 30 lots. Page 30 lordship, it was executed by Girindas who expired. His legal heirs are on record. Then Ashok Das, who is the defendant number 1. And the second party, lessee was where lordship, Mukul Bordolai, and Mosumi number 2 is the Mosumi Khan Das. So here in the present appeal, Lordship, the Mukul Bordole also expired, so his legal heirs are on record, and Mosmi Das is alive. She is the
लिख ले last line. Relatives. He further submits that the present applicants were the lessee in respect of the plot of land measuring 4 kathas 12 lechas, which is the suit land in the title suit. This 4 katha is the suit land.
yes, Lordship, 4 kathas 12.
12 lechas, which
Of
is the
that
suit
number
land in
274, pata number
title suit number 11/2026. And who were the lessers?
Lessors were, Lordship, according to this page 30, Lordship, lessors were Mukul Bordole.
Who is Mukul Bordole?
Mukul Bordole was one of the partners in the firm, Lordship.
Now, how he is related to the defendants?
No, he is not related. After taking the land on lease,
Who
Lordship.
was the owner of the suit land?
Suit land owner was the respondent number 1 and 2, Lordship, and their legal heirs.
They have not leased the.
They had leased it. Green Das, Lordship.
Who is, therefore I am asking, who is Girin Das?
Green Das is the own brother of the husband of the present appellant number 1, Lordship, Mosumi Das Khan. And Green Das, Ashok Das, they are own brothers. And the husband of Mosumi Das, Lordship, present appellant, name is Parasmani Das, Lordship. They are all 3 brothers, out of which Green Das has expired, Lordship. And his legal heirs are on that. And Mukul Bordole also expired. His legal heirs are on record.
Learned counsel for the applicant has further submitted that the suit land was leased to the predecessor in interest of lease to the applicant number 1 and 1 Mukul Das by
Mukul Bordole.
By the present respondent number 1 and the predecessor in interest of other respondents, namely Girin Das, by executing a lease deed
Dated 1912. At page 30 in the left side, your Lordship will see the date. Left side.
on
1912.
19/12/2016. He further submitted that there was a stipulation in the said lease deed that the lease deed would be effective for a period of
15 years.
15 years. That is,
It is mentioned in page 31, clause 2.
15 years. And where is the stipulation that it will be again renewed?
This is the renewal. It will be again, yes, yes.
You made some submission.
After Lordship, clause 2 itself says, upon completion of the lease period of 15 years, a fresh agreement shall be executed between the
He
parties.
further submits that there was also a stipulation that after completion of the period of 15 years, a fresh lease agreement would be executed between the parties. Stop, next para. He, however, submits that in however, he however submits that the respondent number 1, namely Shri Ashok Das, had preferred a writ petition before this court, which was registered as WPC number 4499/2020. Wherein the said writ petitioner / respondent number 1 suppressed the fact before the court regarding existence of the aforesaid lease deed and prayed for issuance of a direction to the Indian Oil Corporation to immediately stop operation of petrol pump, namely Messrs. Purnima Fillings Station from the Suitland. Learned counsel for the petitioner submits that that petrol pump is not there now.
No, it is there, but IOC has stopped supplying of fuels.
In pursuant to the writ court's order.
Yes.
Learned counsel for the petitioner has submitted that the petitioners are in possession of the Suitland. Where is the plaint or the injunction application which you are referring?
Memo. Memo.
Memo.
Plaint and injunction, Lordship. Plaint, your Lordship will find in the page 11. Page 11. And injunction application is page 28.
Why you preferred this, file the suit?
I filed it because Lordship, the respondent attempted to try it on 10th of
On
February.
10/2/2026. That is the reason.
That is the reason.
Last line. Possession over the Suitland. However, on 10/2/2026, the present respondents, along with their men, came to the suit premises and tried to dispossess the present petitioners therefrom. Accordingly, the petitioners were compelled to approach the Court of Learned Civil Justice Senior Division by filing a title suit, which was filing a title suit
TS number 11/20.
for declaration what declaration was?
Declaration, confirmation of position, and injunction.
Suit for declaration,
Page
confirmation and
24.
confirmation of possession as well as permanent injunction. In the aforesaid title suit, the present applicants had also prayed for had also preferred an application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure 1908, praying for grant of temporary injunction. The said application was registered as Ms. J case number 20/2026. In the aforesaid application filed by the present petitioners, they have also prayed for dispensing with the notice to the opposite parties, considering the urgency of the matter, and grant ex parte ad interim injunction against the respondents, against the opposite party, restraining them from dispossessing the petitioners or alienating the properties. No, dispossessing the petitioners from the suit premises. Learned counsel for the petitioner has submitted that in spite of a specific abatement made in the plaint as well as injunction application, that the opposite parties / defendants tried to dispossess the applicants from the suit premises on 10/2/2026, and the matter was urgent in nature, calling for grant of an ex parte ad interim injunction. However, the trial court, without considering the aforesaid fact and without making any observation as regards the prayer for dispensing with the notice to the opposite parties while granting ex parte injunction, merely issued notice to the opposite parties, fixing 2nd of March 2026 as date for filing of written objection. Stop. Learned counsel for the petitioner further submits that notice was served
Yes, Lord. It was.
that on the next date, in spite of due service of notice, the opposite party did not appear before the trial court. However, the trial court extended the date and fixed next date on 24th of
March.
May. 24th of
March 26. I am having this certificate.
thereafter.
Thereafter, it is fixed on 20.
You have the
22nd of-
orders
I am having this certificate.
on 24th of March. He further submits that on 24th of March also, the opposite party failed to appear.
They had appear on 24.
24th of March, the opposite party appears and sought time for
Filing of this.
filing objection, which was allowed. He submits that the next date of the aforesaid Miss J case is now fixed on
22nd of
22nd of May. He submits that in spite of specific averment made by the petitioners in their injunction application regarding the urgency of the matter in view of the attempt by the respondents to dispossess the applicants from the suit property on 10/2/2026. No interim protection was granted. Stop. I have considered the submissions made by learned counsel for the petitioners. Let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20 May. Stop. However, considering the submissions made by learned counsel for the petitioner as discussed herein above, as well as considering the specific plea taken by the present petitioner before the trial court that the opposite parties tried to dispossess them from the suit premises on 10/2/2026, the till next returnable date, the opposite parties are directed to maintain status quo in respect of the suit property. So, suit land list accordingly on 22nd of May.
Obliged.
20 May.
Item 7.
May I please below?
Good idea.
Lordship, here my claim case has been dismissed, Lordship. Only the ground is that one of the eyewitness was.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellants impugning the judgment and order dated 12/2/2026 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MSC case number 1865/2021, whereby the application filed by the present appellants under section 166 of the MV Act was dismissed. Stop. I have considered the submissions made by learned counsel for the appellant as well as perused the grounds stated in the memo of appeal. This appeal is admitted. Let the records of the MSC case number 1865/2021 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice within 7 days from the date of this order by speed post as well as by usual mode, returnable on 27th, 22nd of May, list accordingly.
Item eight,
Eight, Lordship, this is for enhancement of compensation, Lordship.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the appellants slash claimant impugning the judgment and award dated 30/1/2026 passed by the Motor Accident Claims Tribunal, Kamrup Metro in MEC case number 2832/2019.
Motor accident claims tribunal number 2.
Stop. The appellant is aggrieved mainly with the quantum of the compensation awarded to him. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Call for the records of MEC case number 2832/2019 from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd.
2 may kindly be mentioned, Lordship. MSCT number 2.
No, it will be mentioned by the registry.
item nine,
22nd.
Wait,
মেট্রো অফিসত একবার চেম্বারে যাব।
Wait, this is your lordship. This is a statutory appeal, lordship. The judgment is passed in favor of a dead person, first of all, and then compensation is granted to the owner of the vehicle. She is the mother of the claimants, and the deceased was the husband of the. So these are the main grounds, lordship.
Heard Miss R.D. Majumdar, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been referred by Oriental Insurance Company Limited, impugning the judgment and award dated 18/12/2026 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MEC case number 732/2018, whereby the appellant was directed to pay a compensation amount of rupees 27,81,500 along with an interest at the rate of 6% per annum to the respondent's claimant. I have perused the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents. Let the records of MEC case number 732/2018 be called for from the concerned tribunal. Registry to take steps for requisitioning the aforesaid records. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd of May.
There is a I, but lordship will not give, so let it be there.
We'll let them appear.
Yes. Highly obliged.
I'm taking a short break of 1 minute.
May I please? Statutory appeal, lordship, only grounds is that, lordship, the time of accidents, the vehicle which was, lordship, by the party in this case was not a, lordship, effective policy. So expired policy was there, and on the basis of that expired order,
Okay.
policy,
Heard Mr. J. Kolita, the learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant, the Oriental Insurance Company Limited, impugning the judgment and award dated 10/12/2025 passed by the Motor Accident Claims Tribunal, Bongaigaon, in MEC case number 164/2021, whereby the appellant was directed to pay a compensation of rupees 4,06,000 to the
50% of the award,
50% of
50% of 4 lakh.
50% of the awarded amount of rupees 4,06,000 to the appellants, to the respondent/claimant, along with interest thereon. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 164/2021 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 22nd May.
Is there also
We'll issue notice now.
in IA also.
Now, in IA issue notice. Let them appear.
Public.
Orders, item 12.
May I please, my lord? I'd like to withdraw this appeal.
What is your name?
C. Sharma.
Heard Mr. C. Sharma, learned counsel for the appellant. Also heard Ms. S. Yasmin,
Yes.
learned counsel for respondent number 1 and 2. It is submitted by learned counsel for the appellant that appellants do not want to pursue this appeal and they may be allowed to withdraw the instant appeal. The prayer is allowed. This appeal is dismissed on withdrawal.
Interim order pass alia shall be vacated.
The interim order passed in the connected interlocutory application shall stands vacated and disposed of.
Deeply placed.
Much obliged, Lord.
Item 13. Item number 13.
Who is for the appellant?
Your Lordship, I'm for respondent number 5.
None appears for the appellant on call. Miss, what is your name?
A day.
Miss A. Day, learned counsel for respondent number 5 is present. Let this matter be listed again on 24th of April.
Item 14 and 15.
Case, my lord, where I am the, my lord, alleged seller, the defendant in the trial court. My lord, the suit was for specific performance filed by the respondent herein. He was a plaintiff also. He has also laid a challenge, filed a second appeal. But the issue is that I am the owner. The trial court, my lord, in his specific performance suit, rendered a finding that I am not the owner. And that is why the first appeal, my lord, RFA 73 has been filed for claiming that I am the rightful owner. This was a admitted case between the parties. All throughout the plaint, the written statement, his
This
evidence.
appeal has been admitted or not?
My lord, it has been admitted, my lord. The original record is also here. This has been argued, my lord, 3 times, my lord, it was parted at the
Then
workshop.
why it has come in orders column?
Because, my lord, the quorum changes here, and that is why we are again before my lords to re-argue the matter, my lord.
We'll fix a date of hearing.
I am so grateful, my lord.
What is your name?
Amanpreet Singh, my lord.
Heard Mr. A. Singh, learned counsel for the
Any
appellant.
short date maybe?
Majumdar, IS Majumdar.
Also heard Mr. I.S. Majumdar, learned counsel for the respondent. It is submitted at bar that this appeal was already admitted and was also heard by a coordinate bench of this court on earlier occasion. It is submitted that this this appeal ought to have been listed in hearing column as the matter is ready for hearing. The prayer is allowed. Let this matter be listed. 11th of June.
My lord, if it can be, my lord, earlier, I'll tell my lords why. My lord, I am the owner. I was dispossessed in 2013, my lord. He's enjoying the rental also from the property.
Before June, in the month of May, we don't have dates. 2nd of June.
Anyway, I'm so grateful. Let it be on the top of the board, my lord. It can come up.
On that day, you make a prayer.
My lord,
Before the,
otherwise, I know my lords are always with the heavy board, and that is the reason why I'm asking.
before the court, before which it gets listed, you may make prayer before that court
Very well.
on that day.
I'm so grateful.
Item 16.
May I please lordship, according to office note dated 16/3, credit card of respondent number 3 is not been received back, lordship. So matter may be sent to Loajima Court, lordship, for consignment of trade consignment, lordship.
No, when have you taken steps? Heard Miss, what is your name?
Paying, lordship,
A. Paying,
on behalf of S.N. Krishna Treya.
appearing on behalf of Mr. S.N. Krishna Treya, learned counsel for the appellant. Also heard Mr. S. Sharma,
On behalf of
eh, appearing for respondent number
1.
1. It appears from the office note dated 16/3/2026 that the AD card in respect of notice issued to respondent number 2 has not been received back. It also appears that the notices were issued to the said respondent by speed post on 2/3/2026 stuff. In view of above, the registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post before this court on the next date fixed. Let this within a month. Let this case be listed again on 8th of May.
Lordship.
Item 17.
May it please to your lordship. Lordship, we have taken steps for respondent number 3 in her new address on 23/3/2026. That's not reflected in the office now.
By speed post,
Yes, lordship.
heard Mr. R.K. Mahanta, learned counsel for the appellant. Also heard Ms. K. Sharma, learned counsel for respondent number 1 and 2. Learned counsel for the appellant submits that the appellant has taken steps for issuance of notice upon respondent number 3 by way of speed post on which date?
23/3/2026.
23/3/2026. However, no reflection to that has been mentioned in the office note. That fact has been mentioned in the office note. Stop. The registry is therefore directed to place postal track consignment report of notice sent to respondent number 3 by speed post before this court on the next date fixed. Let this matter be listed on 27th of April.
Please.
Your lordship.
May you please, your lordship? Your lordship, we have already taken step on respondent number 3, your lordship, but the stay notice are yet to be served, lordship. So we needed some time to file affidavit for service of notice of the stay, your lordship, upon respondent number 3.
You have served.
Not yet, your lord, to be served, your lordship.
Okay. Heard, Miss, what is your name?
Miss R. Tado, your lordship.
R.
R. Tado.
R. Talo, learned counsel for the applicant, who submits that though the applicant has taken steps for issuance of notice on respondent number 3 by way of Dasti, some more time may be granted to file an affidavit in compliance thereof. The prayer is allowed. Let this matter be listed again on 4th of May.
Item 19.
Please, your lordship. Lordship, actually, we were supposed to take steps, lordship, on spot number 2 and 3, but we couldn't, lordship.
Why?
Grant us some time, lordship, we will take steps.
No, we are dismissing this appeal.
Lordship.
You have not complied with the court's order.
This is the first time, lordship, we have failed, lordship. We'll 3 days.
Where is
lordship.
the law that first time you should be
Lordship, 3 days,
condoned?
lordship. Within 3 days, we'll take steps, lordship.
Heard, Mr. What is your name?
Yes, Sarania, lordship.
A. Sarani, learned counsel for the appellant. Also heard Miss
R. Shah for respondent number.
R. Saha, appearing for respondent number 1. Learned counsel for the appellant submits that due to some unavoidable reasons, the appellant could not take steps for issuance of notice upon respondent number 2 and 3, as was directed by this court. Stop. He prays for some more time for taking steps for issuance of notice upon respondent number 2 and 3. The prayer is allowed. The appellant shall take steps for issuance of notice upon the aforesaid respondents within 7 days from the date of this order, by speed post as well as by usual mode, returnable on 8th of May. Yes.
Lordship.
Item 20, 21, and 22.
May it please your lordship. Lordship, as per order dated 18/2, appellants were directed to take steps by way of justice service. And accordingly, we have justice service has been completed and office noted 25/3. We have also filed affidavit cum declaration, which has been placed in record. Lordship.
How many respondents are there?
2 respondents.
Heard, Miss, what is your name?
T. Bora.
P. Bora, learned counsel for the appellant, who submits that In pursuant to the directions of this court, the appellant has served the notice upon the respondents by Dasti mode and in compliance thereof have filed an affidavit inter alia stating therein that the notice on respondent number 1 and 2 were served on them on 7/3/2026. The copy of notice wherein the signature of the recipients, that is respondent number 1 and 2 are also endorsed, are annexed along with the affidavit. In view of the averments made in the affidavit in compliance filed by the present appellant, the notices issued to respondent number 1 and 2 are held to be duly served. The records are there. Let these appeals be listed for hearing, as the records of the trial court have already been received. List this matter again on 11th of June.
Of next.
Item 23.
May I please your lordship? Lordship, as per office note dated 5/3/2026, postal consignment of the respondent number 1 would not be tracked, lordship. As postal department system, the postal tracking of any consignment lasts only for 3 months, lordship. FH notice can be issued, lordship, against respondent.
Mr. A.U. Ahmed, learned counsel for the appellant. Also heard Ms. M. Chaudhary, appearing for respondent number 3. Office note dated 12/2/2026 mentions that the postal track consignment report of notice sent to respondent number 1 could not be traced out as notices were sent more than 3 months earlier. When have you taken steps?
Lordship 1/23/2024.
Then how 3 months?
No, lordship, as per office note dated 5/3/26.
No, but 3 months have not lapsed. This office note is wrong.
No, lordship, kindly see the 5/3/26 office note dated.
Yes.
And where, as per the postal department system, postal tracking of any consignment lasts.
Therefore, I am asking when you have taken steps for issuance of notice.
Year 24.
Oh, 24.
24, lordship.
Okay. The appellant is directed to take fresh steps for issuance of notice upon respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 4th of May.
Must oblige, lordship.
Item 24. Item 24.
Mr. R.C. Paul is not there. None has appeared for the applicant on call. Mr. J. Kalita is present. Learned counsel for respondent number 4 is present. Let this matter be listed
27.
again on 27th of April.
Item 25.
May it please your lordship.
Yes.
Your lordship, on the earlier occasion, the matter has been referred to mediation center, your lordship. Your lordship may peruse office note dated 13/3/2026. There is a report, your lordship, flag X.
What happened in mediation?
Lordship, mediator has prayed for some other time, your lordship. Flag X dated is on 7/4/2026, your lordship.
Heard Ms. P. Thakur, learned counsel for the appellant. Also heard Ms.
P. Sharma for
P.
respondent number 1.
P. Sharma appearing for respondent number 1. On perusal of the office note dated 13/3/2026, it appears that the Secretary Mediations Center, Secretary Gauhati High Court Mediation Center has prayed for extension of further time for mediation till 7/4/2026. On the basis of the report furnished by the mediator in that regard. Stop. The prayer is allowed. Let this matter be listed on 24th of April for mediation report.
Authorized, your lordship. Bless you.
Item 26.
As per last office note dated 16/2/26, it has been reflected that neither unserved notice nor AD card has been received yet.
What is to be done?
Lordship, the matter may be sent to Lavazima Court as there are 23 numbers of respondents in this particular case.
Okay. Heard Mr. S. Sharma, learned counsel for the appellant. It appears from office note dated 16/2/2026 that the notice issued to respondents have not yet been received. It is submitted by learned counsel for the appellant that there are 23 numbers of respondents in this case, and therefore the matter may be referred to Lavazima Court. Yes, stop. The prayer is allowed. Let this matter be placed before Lavazima Court to be listed again before the regular court after due service of notice on all the respondents. List accordingly.
Grateful.
Item 28.
May it please your lordship, matter may be passable for the time being. My senior is on leg, lordship.
Now, why it is listed?
Lordship,
Why it is listed in orders column?
My lord, service was not completed, my lord. Now, my lord, we have appeared for respondent number 1 to 4, and 7, 8, 9, 10, 11, 13. 12 already expired, man. So service is completed, man.
What is your name?
Amen on the behalf of our child.
Lord Miss S. Ahmed, learned counsel appearing on behalf of Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr. S. Das, appearing on behalf of respondent number 1 to 4,
7 to 11 and 13.
as well as 7 to 11 and respondent number 13. What happened to 5 and 6?
5 and 6, my lord, circle officer and state of Assam, my lord.
Who is appearing?
Government will appear. 5 and 6. Substitution and zero.
Miss, what is your name?
Kalita.
Miss M. Kalita, learned government advocate, appears on behalf of respondent number 5 and 6. The appellant is directed to furnish. You have received memo of appeal.
Well, I have received, ma'am.
Memo of appeal along with annexures to be learned to the learned government advocate appearing for respondent number 5 and 6. Who is left?
But 12, my lord, probably earlier struck off, my lord. But there might be some orders, my lord, regarding the date of, my lord, respondent number 12.
It also appears that by order dated 4/2/2026, the name of respondent number 12 was directed to be struck off from the memo of appeal. Hence, it appears that the appearance of parties in this appeal is complete. It is yet to be admitted.
Yes.
You have raised a question of maintainability.
No, my lord.
We can admit it.
It can be fixed for admission hearing, my lord.
Okay. Let this appeal be listed for admission hearing on 8th of May.
Well. Thank you.
Item 29.
Also, I request for passover for timing.
Lordship, yeah, in this matter, your lordship sent for mediation. Mediation failed, your lordship.
Mediation failed.
Mediation.
This is your lordship. Lordship will peruse office note dated 19/3/26. LCR received lordship, respondent to file wakalatnama. For 3 lordship, mother received. 1 left. But the usual process report is not yet received, lordship. So the registry may be directed to get the report of usual process. We had taken by both ways. Steps by both ways.
How many respondents are there?
3 only, lordship. 1 is the claimant.
Who is appearing for one?
That is,
I'm appealing for respondent number 1.
oh, you are appearing.
One.
1, the claimant.
Two.
Then lordship service is complete. 3 also mother received.
Heard. You filed wakalatnama.
This morning, your lordship.
Okay. Heard. Miss R.D. Majumdar, learned counsel for the appellant. Also heard Miss
B. Datta, your lordship.
B. Datta, who submits that she is appearing for respondent number 1 and has filed her wakalatnama this morning only. Also heard Mr. A.K. Kanu appearing for respondent number 2. It also appears that notices issued to respondent number 3 was received by the mother of the respondent number 3. Stop. As per the report of the process server. Stop. Hence, the said notice is deemed to be duly served upon respondent number 3. The appearance of parties in this appeal is complete.
LCR received lordship.
The records of the concerned MSC case has also already been received. Therefore, this appeal is ready for hearing. Let this matter be.
Your lordship, we have not received any formal notice
Memo.
regarding this matter.
Lordship, otherwise how do they know? Lordship, I find it very strange when parties appear and then they say ki we have not received any memo of appeal, lordship. I'll give the copy, she can make the copy. No issue with that. And it
Your
can be,
lordship, we came to know about this matter through the
you can
court
make a copy of it.
Through cause list.
before.
I don't understand how
Oh,
cause list
that may happen.
how cause list will reveal which is the party, lordship, the address, the everything. How cause list will
They may be tracking.
Yes, your
I-
lordship. Yes, correct.
She can make, lordship. I do not have any issue. I've given, she can make and give it back to me.
The learned The appellant is directed to furnish copies of memo of appeal along with annexures to the learned counsel for respondent number 1. You have received? Stop. Let this matter be listed for hearing on 16th of June.
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 Can it be in May, Lordship? Because not a big issue.
No, May we are full.
Okay.
Item 32.
Your phone number to them will be there.
In 32, there is a delay of 83 days in preferring the appeal.
By the insurance company.
Yes, fine. Party naam to Dipankar. Oh, sorry.
The notice have been served duly. The opposite parties have appeared.
Yes, madam.
Number 5, ma'am. Number 5.
I am appearing for respondent 1 and 2.
And Mr. Talukdar, you are appearing for respondent number
1 and 2, Lordship.
and Mr. Kolita
Respondent number 5, my lord. 5.
and you. 4. What is your name? S. P.S. Raja. Heard. Okay. Are you opposing?
No, Lordship, I have no objection.
We have no.
Heard Mr. A. Bhattacharya, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for respondent number 1 and 2 / claimants, comma, Mr. T. Kolita, learned counsel for respondent number 5, and Mr. P. S. Raja, appearing for respondent number 4. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of how many days? 83 days in preferring the connected MAC appeal, whereby judgment and award dated 28/10/2024 passed by the Motor Accident Claims Tribunal Morigao in MAC within bracket death case number 56/2016 has been impugned. Since the claimants, that is respondent number 1 and 2, have raised no objection against the prayer made by the applicant, the notice to respondent number 3 is hereby waived. The learned counsel for respondent number 4 and 5 have also not made any objection against the prayer for condoning the delay. Stop. Considering the submissions made by learned counsel for the appellants, learned counsel for the opposite parties, as well as considering the grounds stated in the present application for showing cause for belated filing of the connected appeal beyond the prescribed period of limitation to be sufficient cause, comma, the delay of 83 days in filing the connected appeal is hereby condoned, and this interlocutory application is accordingly disposed of. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it. List accordingly.
My name may be shown in the.
Name of Mr. M. Talukdar may be reflected in the cause list while listing the connected MAC appeal for admission. Name of Mr. T. Kalita. Your name has been reflected. T. Kalita may also be reflected as the engaged counsel for respondent number 5 in the cause list henceforth.
Copy of the memo appeal may be furnished.
The appellant shall furnish requisite numbers of copies of memo of appeal along with annexure to the learned counsel for the respondents.
Item 33. 33 also arising out of same accident, my lord.
Yeah, I'm appealing for respondent number 1. Proceed.
Same accident.
Yes.
And this is also delay condonation.
Yes, ma'am. Delay of 69 days.
Same order. Call Mr. M. Talukdar appears for respondent number 1.
I am not engaged in this case.
P.S. Raja is appearing for respondent number
3.
3. You can appear.
Can inform the company, my lord.
Mr. T. Kalita receives notice on for respondent number 4. Baki ek order hobo delay condon. Same orders as in earlier case.
Item 34.
No copy.
There's a delay of 246.
How many days?
243.
200?
43 days.
Yes, Ms. Kalita, you are opposing.
No, sir.
You are for claimant.
Claimant respondent 1 and 2 loss.
Heard Mr. R. Goswami,
Okay.
learned counsel for the appellant. Also heard Mr. J. Kolita, learned counsel for the claimants / respondent number 1 and 2. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of 243 days in preferring the connected MAC appeal, whereby the judgment and award dated 29/6/2024 passed by the Motor Accident Claims Tribunal, Dibrugarh, in MSC case number 16/2022 within bracket D has been impugned. Learned counsel for respondent claimant submits that, considering the grounds stated in the instant interlocutory application, he does not have any objection if the aforesaid delay is condoned. Considering the fact that claimant is not opposing the prayer for condonation of delay, the notice to other respondents is hereby waived and stop. I have also considered the grounds stated in this interlocutory application, whereby cause of delay has been explained. It appears that the delay has been sufficiently explained by the applicant. Stop. Accordingly, this interlocutory application is allowed and the delay of 243 days in preferring the connected MAC appeal is hereby condoned. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by registry.
My name doesn't mention.
Name of Mr. J. Kulita may be reflected as engaged counsel for the claimant henceforth in the cause list.
And also memo of appeal.
The He will furnish.
Lodge. Oblige, Lodge.
Your Lordship, I'm praying for Passover for the day, Your Lordship, as my senior is out of station.
Prayer rejected. You make your submission. You are appearing for
Respondent number 1, the claimant.
claimant. You are opposing.
It's for delay, I think, Your Lordship.
Your Lordship, respondent number 2 and 3 also are yet to appear, Your Lordship. My senior is out of station and then
How much delay is there?
39 days.
What is your stand? Are you opposing?
Yes, Your Honor, if they have deposit 50% of amount.
No, that is a day. That is a later.
Then we have no objections. If they are not, then we have objections.
Heard, Miss, what is your name?
Hartado.
Talo Learned Counsel for the applicant. Also Miss B. Dutta, Learned Counsel for respondent number 1. One claimant. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, namely United India Insurance Company, praying for condonation of delay of 39 days in preferring the connected appeal, whereby judgment and award dated 22/4/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro in MSC case number 2788/216 has been impugned. Ms. Datta, Learned Counsel for the respondent claimant, submits that considering the grounds stated in the instant interlocutory application, she does not have any objection if the delay is condoned. Since the claimant is not opposing the instant interlocutory application, the notice to other respondents is hereby waived. After considering the grounds stated in this instant interlocutory application and treating instant interlocutory application, this court is of considered opinion that the applicant was prevented from approaching this court within the prescribed period of limitation due to sufficient cause. Accordingly, the delay of 39 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Everybody of judgment, item 51 of supplementary list.
File to them. For reasons mentioned in the judgment, the appeal is allowed and the order of the first appellate court, judgment and order of the first appellate court is set aside. You can go through the judgment tomorrow in the website.
Yes, my lord.
Item 52.
For reasons mentioned in the judgment, the appeal is allowed. And the case is remanded back to the first appellate court with a direction to the First Appellate Court to consider the application filed by the original plaintiff, which was registered as petition number 786/2015 under Order 41 Rule 27 of the Code of Civil Procedure. After considering the said application and depending on the outcome of consideration of the same, the appellate court shall proceed with the appeal and dispose of the same by delivering a fresh judgment after taking into consideration all aspects and materials available on record. Since both the parties are represented by their engaged counsel before this court, they are directed to appear before the First Appellate Court, either in person or through their engaged counsel on 18/5/2026.
Item 53. Item 54.
This civil revision petition is dismissed for the judgment stated in the, for the reason stated in the judgments. Yes.
May I mention item number 67, my lord, with the consent of the other side? Let it be taken up second.
Second appeal.
Second appeal.
Heard Mr. O.P. Bhatti, learned counsel for the applicant.
I'm for the applicant, my lord. My colleague is for the opposite party.
Who
But
has
I-
filed the intern IA?
I filed.
Yes.
Learned counsel for the
As doctor.
appellant/opposite party. Also, Mr. S. Datta, learned counsel for the respondent/applicant. A prayer for adjournment has been made by the learned counsel for the learned counsel for the appellant, to which learned counsel for the respondent.
On both joint prayers.
On a joint prayer made by both the learned counsel for both the parties for adjournment of this case, the same is allowed. Let this matter be listed.
2nd April, my lord. Because injunction application is there.
20 April.
2nd April.
Second may be difficult.
My lord, thereafter my senior colleague has some problem, my lord, after 2nd, my lord. So.
Let it do second.
2nd April.
Okay, 2nd April.
My lord,
Second.
they have filed one objection that may be called for, my lord.
The registry is directed to place the written objection filed by the appellant with the records on the next date fixed.
I know, must have.
Item 28, Lordship. Sorry, Lordship, I could not appear. My junior was there. Your Lordship has fixed next date on 8/5/26. It's a simple issue, Lordship. My plaint was rejected against it's a decree, so I filed a regular first appeal. Lordship. So may I pray to list this matter next week, any date, Lordship? My plaint was rejected only on the ground that there is a suit pending, Lordship. In fact, Lordship, cause of action in both the cases are completely different. So next week, any date, Lordship, or this Friday or
It will be after Bihu.
before, if your Lordship.
Before Bihu Asani, so
6 or 7, Lordship, any date. It's
Okay,
not yet admitted, Lordship, in
okay.
admission.
7th.
Obliged, Lordship. I'll inform the other side, Lordship.
You have to inform the other.
Yes, Lordship. Obliged.
Item 36 and 37.
37 is a MAC appeal, Your Lordship. This is not connected with 36, Your Lordship.
Yes. 36.
Your Lordship, if you peruse the office note dated 25th of March, Your Lordship. Service is awaited, Your Lordship, upon response number 1.
No one has appeared.
No, your lordship, not yet, your lordship.
Heard Mr. A. Das, learned counsel for the
Applicant. your lordship.
applicant on perusal of the office note dated. Which office note?
25th of March, your lordship.
25th of March, it appears that the notices issued to respondent number 1 has not returned. The registry is directed to place the postal track consignment report of the notice issued to respondent number 1 before this court on the next date fixed. Let this matter be listed. There are some other cases.
Your lordship had fixed on 29th of April, your lordship.
Let this matter be listed again on 29th of April.
Along with the IA civil.
No,
Please.
it will be otherwise listed.
Yes, your lordship. 29th of April. lordship.
29th of-
Interim order to continue, lordship.
The interim order shall continue till next
37 is not connected here.
37.
Obliged.
Please, your lordship, I'm appearing for the appellant item number 37. Your lordship, the matter is ready for hearing.
Heard Miss, what is your name?
Ardas.
Ardas, learned counsel for the appellant. Also heard Miss K. Sharma, learned counsel for
Respondent number 1 and 4, your lordship.
respondent number 1 and 4, as well as Miss
D. Hazarika.
D. Hajarika, appearing for respondent number 5. What happened to 2 and 3?
Your lordship, as per the process service, notice of R was received by the father and 3 by the daughter. Respondent 3 by the daughter. Office note dated
It appears from office note dated
22/11.
22/11/2023 that notices issued to respondent number 2 and 3 have been received by the father of respondent number 2 and daughter of respondent number 3 respectively. Hence, the said notices are held to be duly served. The appearance of parties in this case is complete. The records of the MSC case has already been received. Therefore, this appeal is ready for hearing. List the same for hearing on 11th of June.
Item
Much
38.
obliged.
It is your lordship. Lordship, as per office note dated 26/3, lordship, the records have been received and service is complete, your lordship.
My lord, I may appear for the sole respondent. My lord, petitioner may furnish us extra copy.
Lordship.
Heard Miss, what is your name?
S. Kataki, your lordship.
S. Kotoki, learned counsel for the appellant. Also heard Mr. G. Bosho, learned counsel appearing for the sole respondent. The records, total records I say, records of the trial court have been received, has been received. Hence, this appeal is ready for hearing. Release the same for hearing on 16th of June.
My lord, meanwhile, I'll file objection. My lord.
Okay. Learned counsel for the sole respondent submits that he has not received the copy of memo of appeal. The appellant is directed to furnish a copy of memo of appeal along with annexures to the learned counsel for the respondent within 2 days from the date of this order. The learned counsel for respondent has also prayed for allowing the respondent to file written objection against the grounds taken by the appellant in the memo of appeal. The prayer is allowed. He may do so before the next date fixed for hearing of this case.
My lord.
List accordingly.
Lordship, there's an interim order.
The interim order shall continue till next date.
Obliged.
Obliged.
Item 39.
Yeah, Lordship. Lordship, as per the office note, the service of respondent number 1, 2, and 3 has not returned yet. So the service may be awaited, Lordship.
What is your name?
Yes, Kathak, Lordship.
S.
Kathak.
Kathar.
Kathak.
Kathak, learned counsel for the appellant on perusal of the office note dated
5/3/26.
5/3/26. It appears that the notice you have not sent notice by speed post. Notice issued to respondents have not yet returned. It also appears from office note dated 18/2/2026 that the appellant has taken steps for issuance of notice on respondent number 1, 2, and 3 on respondents by usual normal post, whereas they were directed to take steps for issuance of notice by speed post. The appellant is directed to take fresh steps for issuance of notice on all the respondents by speed post within 7 days from the date of this order, returnable on 8th of May.
Item 40.
May it please your lordship. My lord,
Yes.
my lord, as per office note dated 5/3/26, notice have been issued, but the unserved notice not returned back.
This I is for?
Containing delay of 168 days.
You are for?
Objection.
One.
You are for?
For restaurant,
Claimant.
opposite party numbers 1 to 5, claimants 1 to.
Basically, my lord, the quantum,
Yes,
ground
there
is
is
quantum,
quantum.
my lord.
And we'll waive the heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for opposite party number 1 to 5 / claimants. Learned counsel for the opposite party / claimant submits that he does not have any objection if the delay in preferring the connected appeal is condoned in this interlocutory application. Considering the submissions made by learned counsel for the respondents, opposite party / claimant, as well as considering the fact that the main grievance in the connected appeal is regarding the quantum of compensation paid to the claimants, the notice to respondent number 6 and 7 is hereby waived. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the reasons stated in paragraph number
4 to my lord. 4 to 10.
4 to 10 of the instant interlocutory application for delay in preferring the connected appeal by the present applicant. Stop. Considering the aforesaid reasons to be sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation, the period of
168 days.
168 days, the delay of 168 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
My name may be shown in the.
The name of Mr. M. Talukdar may be reflected in the cause list as engaged counsel for the claimant's respondent. Come on, henceforth.
Copy of the memo of will I'll furnish.
You file it, I'm not reflecting it in the order.
I'll furnish the copy.
Okay.
Obliged.
Item
I will.
41.
May I please, Your Lordship? Lordship, as per the office note dated 16/3/26, service report has not yet arrived, my lord. Respondent number 1 has already appeared.
One is the insurance.
Insurance.
You are the claimant.
Yes, Lordship.
Okay. When have you taken steps?
Lordship,
You have not taken steps by speed post.
as per the order, I have taken steps, Lordship.
Take fresh steps by speed post also. Then we,
Otherwise, my lord, respondent number 2 and 3 are owner and driver, Lordship. So their name can be strike off, Lordship. The
They-
appeal is for enhancement only, and the award is to be satisfied by the insurance company, my lord. We have no grievance against the respondent number 2 and 3, Lordship.
heard Mr. M. Jaman, learned counsel for the applicant. Also heard Mr. R.C. Paul, appearing for opposite parties number 1. It appears that notice issued to respondent opposite party number 2 and 3 have not yet returned. The learned counsel for the applicant has submitted that since the connected appeal has been filed by the present applicant on being aggrieved by the quantum of compensation paid to him or them,
Him, my lord.
paid to him by the impugned judgment and award, the notice to the owner and driver of the offending vehicle, that is opposite party number 2 and 3, may be waived. Considering the submissions made by learned counsel for the applicant, the prayer is allowed, and notice to opposite party number 2 and 3 in this interlocutory application is waived. You are opposing?
I'll take time. I just filed this, my little color number.
Okay.
383 days delay.
You filed written objection. Learned counsel for the opposite party number 1 insurance companies praise for allowing some time for filing written objection by the insurance company against the prayer for condonation of delay. The prayer is allowed. Let this matter be listed 8th of May.
Obliged, Lordship.
Item 42.
Yes.
May I please, Your Lord? And we have filed this petition, my lord, for injunction, my lord. I have 344, my lord. Objections have been filed, my lord.
You have filed objection.
My lord.
But objection is not there on
Objection they have filed on 7/3.
objection as indicated. It is not there. We will call for the objection and fix another date.
On Wednesday, my lord? No, my lord, let it after view then. My lord,
The entire dispute regarding fishing, my lord. We have cultivated the fish. And dispute regarding, my lord, possession of fish.
My lord, their
So, my lord,
agreement is,
No, let him submit.
yes, continue.
Yes.
And by virtue of, my lord, earlier interim order, we have cultivated, and subsequently, my lord, the interim order has been vacated. So, my lord, we are not able to, my lord, catching the fish.
Fish will be there in the
So
fishery.
they will, my lord. The other side will, my lord,
Oh, they don't have. You are seeking injunction against them.
lost. Is there, my lord, status quo? If you lost it, my lord, then it will be, my lord.
No, my lord, we are object because their term is already expired on 28/3/24. And even up to that period of them not paid the full rent amount. And we are already in possession of the fishery by virtue of the order dated 15/12/25 passed in the Mizja case by the London civil judge.
Immediately on reopening.
My lord,
Immediately on reopening.
my lord, I will reach at Gauhati on 22, my lord. Actually, I am going to out of station, my lord. On 22, there is also bar council election also, my lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. H. L. Moria, learned counsel for the sole respondent, who submits that in connected interlocutory application, and who submits that the applicant has that the respondent has filed a written objection against the prayer for grant of temporary injunction made by the present applicant. However, the said written objection is not placed with the records of this case. So the registry is directed to place the written objection filed by the sole respondent along with the record of the instant interlocutory application and list this matter again on 24th of April.
My lord, may I give a suggestion, my lord? On that date, the appeal itself may be heard. Matter may be disposed the same date. Instead of this miss case, entire matter may be heard.
Okay. But we will not make any observation now.
Obliged.
On that day, you may pray.
Item 42.
My please, O Lordship. I have asked for 17 days delay condonation, and out of 17 days, 13 days was vacation, Lordship. For my personal difficulty, I filed 1 day late and I did not get the benefit of vacation, Lordship. Also, the real condonation is of 5 days, Lordship.
Have you issued notice?
Notice issued, Lordship.
Heard Mr. J. S. Ahmed, learned counsel for the applicant. It appears from office note dated 25/3/2026 that notices issued to respondent number 1 to 3 by speed post have not yet returned. The registry is directed to place the postal track consignment report of the notices issued to the respondents by speed post before this court on the next date fixed. Let this matter be listed 27th of April.
Okay.
Item 44.
My lord, this is an IA for delay condonation of 660 days, my lord.
How many days?
660 days, my lord.
Heard Mr. B. R. Das.
My lord, respondent number 2 and 3 is not necessary party. It may be strike out.
No, not at this stage. Heard Mr. B. R. Das, learned counsel for the applicant. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order. Written returnable on 11th of May. List according.
Alia applies.
May it please your lordship.
What miss, what is your name?
PC Sangma.
PC Sangma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant New India Insurance Company Limited, praying for condonation of 28 days, delay of 28 days in preferring the connected appeal. Stop, issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11th of May.
Item 46.
This is also first time lordship, 22 days delay.
Ms. R.D. Majumdar, learned counsel for the applicant insurance company. This application has been preferred by the applicant insurance company, praying for condoning the delay of how many days?
22,
22 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 11th of May.
Item 47.
Lordship here also first time, 450 days.
Same order, 450 days, 11th of May.
Alia applies.
Item 48.
Lordship, there is a delay of 249 days in filing appeal.
Same order, Council M. Talukdar, 249
days.
49 days,
11.
11th of May.
Item 49.
Lordship 77 days.
Same order, 77 days,
Alia applies.
13th of May.
Item 50.
Delay of 335 days, lordship.
What miss? What is your name?
R Tadu.
R.
Tadu.
R. Talo. Same order. Delay of how many days?
335.
335 days. 13th May, returnable on 13th May.
Item 57 and 58, along with item for reduction.
Your lordship, with regards to item 57, we have filed the delay petition also along with the substitution, which has been tagged along with the main appeal.
Item 57. This I is for
Condoning the delay in filing the substitution petition, your lordship.
you're opposing.
So, your lordship.
There are other petitions also.
Yes, your lordship, other IEs.
Oh, what are the numbers?
Your lordship, 802 of 2026, that's the substitution petition. However, on the last date, that is
802.
24th March, setting aside was
Oh, the abatement has already been set aside.
yes, your lordship, on the last date,
Okay,
24th
okay.
March.
Yes, some query was posed on that
Yes,
day.
Your Lordship, it was an inadvertent submission on my part. As such, we have rectified the mistake and filed the delay the very next day.
Okay. Third, Miss A. Biani, learned counsel for the applicant. Also, Miss K. Sharma, learned counsel for respondent number,
Both the respondents, Your Lordship.
both the respondents. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant insurance company praying for condonation of
1155 days.
delay in setting aside abatement as well as in filing the substitution application for substitution of the deceased respondent number 1. It is how much delay?
Your Lordship, 1155 days
It is
from the date of death.
stated in the application that the substitution connected substitution application has been filed after a delay of 100 and after a delay of
1155.
1155 days. However, learned counsel for the applicant/appellant has submitted that the applicant came to know about the death of respondent number 1 only on
2nd February.
2nd of February 2026. Stop. The learned counsel for the respondents has not opposed to the prayer of condoning the delay. After considering the submissions made by learned counsel for the parties, as well as grounds stated in the instant interlocutory application, the delay in filing the substitution application is hereby condoned, and this interlocutory application is allowed. This is in 1051.
Yes.
Next is
IA 802.
802. This heard Miss A. Biani as well as Miss K. Sharma. This application under Order 22 Rule 4 of the Code of Civil Procedure has been filed by the applicant National Insurance Company Limited for substituting the legal heirs of deceased respondent number 1, namely late Asma Begum, who had expired on
8/10/2022.
8/10/2022. It is submitted by learned counsel for the applicant that though the appeal got abated, however, the abatement of appeal has been set aside in the connected interlocutory application number
803 of
803 of 2026. She also submits that the delay in filing the present substitution petition has also been condoned in the connected interlocutory application number 1051/2026. Learned counsel for the respondent has raised no objection to the prayer for substituting the legal heirs of late Asma Begum in her place. Stop. Considering the averments made in the instant interlocutory application, as well as after considering the submissions of learned counsel for both the sides, the prayer for substitution is allowed. The name of legal heirs of deceased respondent number 1 within bracket late Asma Begum bracket close are allowed to be substituted in the place of respondent number 1 in the connected memo of appeal. Stop. Accordingly, name of Mr. Muhammad Nizamuddin be substituted as respondent number 1 within bracket A, comma, similarly name of Muhammad Anamuddin be substituted as 1 within bracket B, and name of Muhammad Burhanuddin be substituted as respondent number 1 within bracket C in the memo of appeal of the connected MAC appeal number 146/2004. You will file a amended cost title. The appellant shall file an amended cost title by showing the names of substituted respondents therein on the next date fixed. Let this matter be listed 6th of May. The instant interlocutory. Let the connected appeal be listed on 6th of May. The instant interlocutory application is accordingly disposed of. Anything else?
Yes, Your Lordship, item 58.
What
It's a
is
similar matter, Your Lordship. Respondent number 1 has expired and we have filed the 3 petitions.
here also abatement is allowed?
No, Your Lordship, this was not taken up on the last date.
Okay. Heard Miss Abiani, learned counsel for the applicant. Also heard Mr. K. Sharma, learned counsel for the respondent. This application under section 5 of the Limitation Act has been filed for condoning the delay in referring the connected application and for setting aside abatement, as well as for substituting the legal heirs of deceased respondent number 1, Asma Begum.
Your Lordship, same days, 1155 days.
Yeah, the orders will be same.
Same, just the date of knowledge is different, Your Lordship. In the last case, it was 2nd February, here it is 9th of February. Apart from that, everything is same.
Copy करना. Same order. I will check the order. The you likhna up, I will see later. The petitions are allowed. All the 3 petitions are allowed.
Amended cost.
Amended cost title, same date.
Much obliged, Your Lordship.
Yes. You have been informed?
I've just been informed that the date has been changed. So I don't know their urgency, but I needed some time. I have not even received all the set of documents from the client. So since they have already taken the date.
Anybody? No, I have not finalized.
Then I'll try to inform them.
Both of you appear together.
Yes, yes. If I can get hold of them, then I'll.
Yes, then I will On mutual consent of
Fine.
both the parties, I will fix a date.
Highly authorized.
Still, there is some time left.
Item 59.
May it please your lordship. Your lordship, we are yet to file our affidavit regarding justice service upon respondent number 2. Kindly allow us another 2 weeks time or 1 week.
Heard Mr. S. Datta. This is item number.
9, your lordship.
Heard Mr. S. Datta. Learned counsel for the appellant. IA has been disposed of.
No, your lordship.
One I is pending.
Yes, IA number 149 of 2018 is pending
Or,
for stay, your lordship.
okay. Also heard Mr.
NI Khan
N.I. Khan,
for respondent number 1.
appearing for respondent number
1.
1.
1A, 1B,
1 has been
1A, 1A,
1A,
1B,
1B, 1C. Learned counsel for the appellant has prayed for some time for filing affidavit in compliance regarding service of notice by Dusty mode on respondent number 2 and as regards 3.
Your lordship, there is no other respondents, only
Only 2
one.
respondents are there.
On respondent number 2, the prayer is allowed. Let this matter be listed again. 6th of May for filing a stay petition. Will decide later on.
Yes, your lordship.
Let this matter be listed on 6th of May.
Item 60.
Lordship, as per last order details, as per last order, your lordship had directed us to take steps upon respondent number 2. But the same could not be complied with due to some personal difficulty on part of the conducting counsel.
Heard Mr. S. Sharma, learned counsel for the appellant. He submits that the appellant could not take steps for issuance of notice upon respondent number 2 as was directed by this court, due to some personal difficulties, and prays for some more time for taking steps. The prayer is allowed. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by usual mode as well as by speed post within 7 days from the date of this order, returnable on 4th of May.
Item 61.
The last order dated, as per your lordship last order, we were directed to take steps upon respondent number 2A, who is the legal heir of respondent number 2. And as per the office note dated 27/2/2026, no response has not yet been received. We may await the lordship.
When have you taken steps?
We've taken steps on
24/2/2026.
Notice has been issued.
Heard Mr. S. Sharma, learned counsel for the applicant. Office note dated May 27/3/2026 shows that the notice issued to respondent number 2 within bracket A has not yet been returned. So the registry is directed to place the postal track consignment report of the notice issued to respondent number 2 within bracket A by speed post on the next date fix. Let this matter be listed on 27th of April.
Item 62.
May it please your lordship. My lord, the records has been received and. matter can
Who
be
is
fixed
for the other side?
My lord, as per the previous order, no separate notice was required to be issued.
Why?
Already we have served the copy to the deputy SGI, para 6, my lord, of the last order.
Oh, this is item number.
62.
Oh, name of the SJ is there. Heard Mr. D. Rathi, learned counsel for the appellant. No one has appeared for the respondent. Though the name of Deputy Solicitor General of India has been reflected in the cause list. It appears that the records from the concerned railway claims tribunal have been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing. 16th of June.
Much obliged, my lord. Similar play in respect to 63 as well.
63.
Yes, my lord.
Same order. 16 June.
Much obliged.
Item 64.
May I please be Miller? Lots of as per office note dated 27/3. 27/3/26 lordship. Process service in respect to respondent 1 is served lordship.
How many respondents are there?
There are 4 respondents lordship. And
As regards other respondents,
respondent 2 returned, process service is returned and stating that the area falls under district and session judge Pasighat. So that could be resent to the concerned district judge lordship for service. But the postal taking is not given lordship. And respondent number 3 lordship, I would like to take fresh steps on the correct address. Another address is there of the respondent number 3 lordship. Respondent 4 is served lordship, LCR has been received. So the process service is there lordship.
as regards respondent number 1 and 2,
1 is served lordship. And
heard Mr. A.R. Agarwala, the learned counsel for the appellant. On perusal of office note dated 27/3/2026, it appears that the notice issued to respondent number 1 has been duly served. As regards respondent number 2,
the notice should be sent back to the concerned district and session judge Pasighat. If the same can be sent lordship.
notice sent to the said respondent by usual mode has returned
The remark.
with a report. The notice issued to respondent number 3 could not be
Delivered.
delivered
No such address.
as
No such person.
as the addressee was not found in the given address.
4 is served lordship.
And the notice issued to respondent number 4 is served as per the postal track consignment report. Accordingly, notice issued to respondent number 1 and 4 are held to be duly served. As regards respondent number 2 and 3 are concerned, the appellant shall take fresh steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on
Lordship, this
4th of May.
that process service of respondent 2 is returned back lordship.
Okay.
Sent to the wrong district session judge.
By speed post only. Speed post
Yes,
only.
lordship, yes.
The the notices which are notices issued to respondent number 2, which have returned, may be sent again
Yes.
for service through the Court of London District and Session Judge Pasigat, East Siang, Arunachal Pradesh. List this matter again on 4th of May.
And Lordship, after these 3 months, this postal tagging disappears. So it is not taking. So
No, 4th of May, you have to take steps now.
yes, Lord, I will take.
Today is 30 March. So it will be there.
But I have another submission there. That postal taking after 3 months it disappears from the computer.
Yes.
So the registry could not track it out.
Oh, that may happen.
And ADs are not returned, Lordship.
Therefore, when the court fixes next date,
Yes.
whenever notices are issued through registered posts,
Yes, Lord.
through speed post, council should point out that the
Yes,
next date should not be beyond 3 months.
Yes, Lord.
That has to be pointed out.
Yes, Lord. Much obliged.
Item 65.
In this case, notices have not been returned. Take exception 23/2/2026. And Lordship, my stay is also pending. Lordship.
When have you taken steps?
Well, notice issued on 20.
Heard Mr. R. Goswami, the learned counsel for the appellant. It appears that the notices issued to respondents number 1 to 3 have not yet returned. Stop. Next para. The registry is directed to place the postal track consignment report of the notices issued to respondent number 1, 2, 3 by speed post, before this court on the next date fixed. Place this matter again on
Stay petition will be considered on that.
27th April. The stay petition shall be considered after due service of notice on the respondent.
Yes, can it, because they might start execution, can it come a little earlier? Because by the time I think service of.
27th April, because we will have a long vacation, Bihu vacation, 27th April.
Yes.
If they move execution application before that, you will come to know.
Yes.
You may approach this court.
Deeply aware.
Item 66.
May it please your lordship. Your lordship, the service upon the respondent number 1 is not complete as per the office note dated 27/3/26, lordship. The insurance company.
Respondent number 2.
Respondent number 2 is the owner of the vehicle, lordship.
Heard Miss M.
Devi, lordship.
Devi, learned counsel for the applicant. On perusal of the office note dated 27/3/2026, it appears that notice issued to respondent number 1 has not returned. However, the respondent number 2 has filed a written objection in the instant interlocutory application which is placed on record. You have a copy of this?
No, Lordship.
The applicant may go through the copy of the written objection from the records. He is not opposing anything. The registry is directed to place postal track consignment report of notice issued to respondent number 1 by speed post before this court on the next date fixed. Let this matter be listed again on 4th of May.
Hearing item 68.
67.
May it please, ma'am.
You made a mention.
Yes, ma'am.
We'll take it up at 4. Your prayer was why you made mention.
My lord, my lord, because there is some urgency, my lord, that is why I thought if it might not reach, that is why, my lord.
I'll take rest for 1 hour. Okay, continue.
My lord, this appeal is against an order dated 9/3/26, my lord, passed by the learned civil judge number 2, Kamrup Metro, my lord. Whereby, my lord,
Notice you are appearing for.
I'm
Your name is not.
I am for the defendant respondent number 2, my lord. I am to file Mogalatma because he is a paralyzed man within 7 days. So on behalf of defendant respondent number 2, Alauddin Ahmed, I have appeared, my lord, on the request of the relationship. So I am allowed 1 week time for filing affidavit and Mogalatma.
What affidavit?
Affidavit. But regarding objection, regarding injunction, my lord, I will humble submit for prayer for interim injunction prayed in this case, your honor. I have no objection if interim prayer is allowed. Granted temporary injunction. Regarding, I have no objection.
Is there any interlocutory application?
I is not separate, I is not. In the prayer only I have asked for it.
What is the prayer?
My lord, may kindly have page 33 onwards, my lord. If I may-
Regarding ground number 2, my lord, this may be considered only because I also filed a civil suit, which was allowed page number 114, my lord.
My lord, first may I take through the prayer, my lord?
Yes. Page number?
33, my lord.
Just a minute.
Yes.
Yes.
Or that, your honor may be pleased to pass an order modifying, altering the order dated 9/3/26 passed in Miss J case number 294 of 26, arising out of title suit number 147 of 26, passed by the learned civil judge senior division number 2, Kamrup Metro, Gauhati, and allowed a prayer for interim temporary injunction in favor of the appellant with regard to the Schedule B property located in the Schedule A property, and thereby directing the opposite parties, more particularly the opposite party number 3, not to take any coercive action against the petitioners in respect of the Schedule B property as appended with the instant application.
Who is opposite party number 3?
Bank, my lord.
And bank has not appeared in this.
Duly served the dusty copy, my lord. It is there at page number, my lord, 166, my lord. Running page 166. I had served on last 25th.
You are seeking any relief against opposite party number 2?
Yes, my lord. 2, my lord. My lord, if I take through the factual metrics, then I can satisfy.
Yes, yes.
My lord, what had happened? My lord, I'll be very brief, my lord, since my respected senior has also acceded to my prayer.
My lord, in this case.
But we cannot dispose of this matter
No,
today.
no, my lord, my prayer for interim may be considered till the next returnable date.
Okay.
Because my lord, 7/4 is the next date before the learned civil judge. So till that date, date may also be fixed, my lord. I have no hesitation.
Okay, what are the facts?
Facts is that, my lord, we were residing in the Schedule B property of flat.
Who?
I, my lord, I, my lord.
Yes.
I being the appellant, I am residing with my children. Now, my lord, what happened?
How much is Schedule B land?
Schedule B land, my lord, I'm taking through the.
It's a flat, my lord, not land.
It's a flat.
Residential.
Flat.
Flat.
And Schedule A?
Schedule A is the land.
Within SDL.
Where
I am the owner of the flat, so he's purchaser.
I had purchased the flat in the Schedule A property whereby it's an apartment, my lord. Apartment.
In apartment,
I am
Schedule B is one of the
flats.
Okay.
Now, my lord, what happens in this case is that the respondent number 2, which my senior appears for, they had purportedly taken a loan from the bank, which is the version of the bank. Now, because of that, the bank comes up with the possession notice because they say that the said respondent number 2, Mr. Alauddin, has not repaid the loan. Now, my lord, my contention in this case is that I am neither a borrower neither a guarantor. Rather, my lord, when that notice was served on 8/1/26, it was affixed on the wall of the said building where I am residing. Luckily, it came to my notice. That is how I came to know. That is my case, my lord. Because, my lord, I am not a privy to the loan. I have nothing to do with it.
Are you a tenant or owner of?
No, I am the owner, my lord.
When you purchased?
I purchased back in 2011. And in
And when the loan was taken?
Loan, my lord?
No, my lord. Regarding, it's a misplaying of facts because there is no question of any loan. This loan is a misrepresentation. There is no any question of loan. The owner, defendant never took any loan. He also never took any loan. The allegation of loan is a false fabricated of the bank. He is misleading the facts.
No, my lord. I'm not misleading. Sir, I'm not misleading.
You have also not taken any loan. I have also not taken any loan. That is why my prayer.
No, what is the contention of the bank?
Contention is that
of the bank.
The respondent bank, respondent number 3, made a false fabricated mortgage loan in the name of a fictitious person. I'm not that person. I'm a third party applicant in the respondent, my lord. So, question of claim of the bank as a false fabricated. Learned Court, page number 114 maybe.
No. Before that, who is the owner of Schedule B flat?
I am.
You purchased it from defendant
By
number
an agreement only, my lord. He has no registered sale deed.
Because they have refused to. I am in physical possession since 2019. That also I filed the title suit. Now, if I open my mouth, lot of things will come out. I can also unearth a lot of things. But my lord, I'll stick to the facts of the case because there is urgency in the matter. My lord, the bank says.
Then why the trial court refused to grant you injunction?
My lord, because my lord would have, that is also there, my lord. Page number 159, my lord. 161, sorry, my lord. 161, sorry, my lord. If I may read, my lord, the relevant portion.
161.
Yes, ma'am.
Yes.
Last portion, my lord. The case admittedly.
Just a minute. There is some proceeding before DRT also.
No, my lord, that is going on. But in the DRT, my lord, I had preferred a SA, my lord, secured the application, my lord. There, my IA was not considered, my lord. The case is still sub judice, my lord. It is a part of the records, my lord, of my petition. But my lord, in that case also, the DRT has not protected my interest. That is why I had approached the honorable civil judge on the strength of a judgment which the Supreme Court had given, Prohibitions judgment. If my lord pleases, I can take through that also. Where the judgment says that because of the summary nature of the DRT, there are certain things which are not within the contours of the DRT, then the civil court can apply, can interfere, my lord, in those cases only, specifically, like ours, my lord.
Okay, what happened?
Then, my lord, what had happened, shall I read
60.
161, my lord?
Yes,
Why the court didn't give civil court?
yes.
The case admittedly relates to mortgage of the suit.
Where are you reading?
My lord, 161, middle portion, my lord. 161 middle portion.
Yes,
The case admittedly relates to mortgage of the suit property by the defendant number 1 with the OP number 3, that is them, my lord. Hence, under such circumstances, it is very much necessary that the OP number 3 bank.
who is defendant number 1?
My lord, Aladdin only. Aladdin is the partner of the partnership firm. 1 and 2 are Aladdin only, my lord.
Okay.
1 and 2 are Aladdin, and 3 is the bank. So, my lord, the honorable civil judge had observed that the bank needs to be heard. Now, my lord, the problem is that the bank has, my lord, they have also admitted, my lord, that the loan, purported loan, my lord. I'm not saying that Aladdin had taken any loan or anything, as my respected senior has just stated. And I am not on that. That is between them, my lord. But I am being made a scapegoat in this entire scenario, my lord. I am a miserable person in this entire scenario, my lord. That is my problem, my lord. Neither I am a borrower, neither a guarantor, nothing.
Why it was refused?
My lord,
That-
it has not been refused. The ad interim injunction was not given.
Okay, you are against that order.
I am against that order because, my lord, there is urgency because tomorrow, my lord, already 13-4 notice has been given by the bank under the SURFACE Act, which states that they have already taken symbolic possession of the property. Tomorrow, my lord, the bank may come up with a sale notice, my lord. That is my grievance, my lord. Then where will I
And
go?
bank has appeared before the
Bank has
trial
appeared.
court.
No, I'll not. DRT, they have appeared, my lord. Trial court, my lord, next date is 7-4, my lord. But, my lord, my problem is, my lord, because they have already taken the symbolic possession on 13-4, my lord, on 8-1, my lord, of this year, my lord, 8-1-26. They can come up with the sale notice on any day. That is why, my lord, I seek protection, some protection, my lord. A date may also be fixed. I've also done dusty service upon them, my lord. It is within their knowledge, my lord, this appeal. I request, my lord, that some protection may be given. I am being made a scapegoat in this entire scenario, my lord. That is my case. If anything is found, my lord, my records may be also, my submissions may be also recorded that my stay may also be vacated. But, my lord, I have not done anything wrong in this case. I have not taken the loan, neither I was a guarantor to the loan. I was just having a property. The bank, without doing a proper title search report, without seeing who is all the persons who are residing in the said apartment, they have mortgaged the entire property. They have acted blindly, my lord. That is my case, my lord.
Where is your dusty?
Dusty starts from, my lord, page 163. And upon bank, I had done it at page 166, my lord. On this 25th only, I submitted, my lord, to them. 166, my lord, would have. Bank seal is also there. Page 166, Rami.
What was the date shown?
Yes, 166 bottom portion. Some protection till the next returnable date. If sale notice is out, my lord, I will be gone, my lord.
Okay.
My lord, in this respect, although I agree that interim prayer of injunction is temporary relief can be granted. I am not in that. But the facts pleaded by this is completely false. This may be clear and my submission will be clear. That is why I paid 7 days time to file an affidavit. Paragraph 115 maybe. Case number 115. This relevant judgment suffraging by petitioner himself also. The facts, why is suffraging? The true fact is this, learned already taken cognizance by learned civil judge, senior division. Another parallel suit is also, another title suit is pending. So,
I am not a party to that suit.
115, my lord. Page number 1, relevant portion showing in the middle last portion. That all the mortgage documents and other loan, the last part, my lord, in this para, in this page 115, in the last portion middle, that all the mortgage documents, it is a submission of the defendant number 2, Alauddin, and defendant number 1 and 2.
Where are you reading?
My
That-
letter.
Okay.
That this may be declared with that matter. That
Yeah.
all the mortgage documents and other loan
Whose
documents.
order is this?
My lord, this is another case which was filed by Mr. Alauddin, the respondent number 2. This is also, this is civil judge number 3. They had approached differently, my lord.
It is my suit, my lord. It is
They had
different
suit, my lord. Not, I am not a part of it.
Okay.
It is my fact, madam. I want to draw your honor also. All the mortgage documents and other loan documents in the name of fictitious Alamuddin. Not I am that Alauddin, my lord, regarding mortgage. Alauddin was illegal, first fabricated. After the bank withdrawal, their original application number 219, important, my lord. And ordered at 24 by filing withdrawal petition before the tribunal, and the bank knew the alleged mortgage was a false. Now again the defendant bank, now defendant number 3, my lord. Here, bank authority with ill motive again issued a demand notice 6/5 on the basis of aforesaid first bogus mortgage to the plaintiff, my lord. I am the defendant number 2 and 1 and 2. The plaintiff being aggrieved also lost an FIR to the police of Poltermazar PS on 28/7/24 against the illegal fabricated mortgage of the defendant number respondent number 3, my lord. The alleged mortgage in the name of fictitious Alauddin Ahmed of Bank of Baroda, River branches of false fabricated with false signature in the all the paper. The defendant bank, my respondent 3, my lord, issued another possession notice 25/9/25 and threatened the petitioner, that is the defendant number 1, respondent number 1 and 2, my lord, to forcefully take possession of that. Against the same, this civil suit filed by another civil suit, my lord. Now he is not misplacing the facts. This civil suit, TS number 468/25, pending before the landed civil judge number 3, my lord. So landed civil judge taking the notes of all these facts, all the mortgage papers, false fabricated, committed by the bank himself. That is the bank. That is why the bank has not appeared, my lord, because against the allegations of false forgery, there are police cases also pending. So learned petitioner.
Whatever you have read now.
In that case,
This
I
is-
can relieve, my lord. Injunction is bank already restrained. So
Injunction.
in that view, your lordship, I submit, honorable submit that interfere claim by him for temporary injunction can be allowed, because first fabricated allegations, serious allegations they are regarding first fabrication of the mortgage and loans. So in this case, paragraph 12, para 12, my lord, page number shown by the 117, may be relevant, my lord. Learned civil judge relied Bank of Baroda versus Ranjan. This clearly stated in his allegation of false forgery is civil has the absolute jurisdiction but no debt recovery. So injunction can be granted. That is why in the light, in view of the decision judgment, this your lordship may peruse the paragraph 21.
Page number?
Page number 117, this petition, para 12, my lord. Clear observation, correct observation of civil court. So right decision cited by learned civil judge number 3, Gauhati. Because exit the acts on allegation of serious false fabricated against the bank's documents, civil court has only the exclusive jurisdiction, not any difference. So that is why the bank has not appeared. So let the bank may file affidavit, false fabricated. Action may be taken against the bank. Fabricated. Learned petitioner in this case does not know what is the main things going in.
Okay.
Actually, there is the entire false fabricated document referred to the bank. I said no any mortgage, no any land value. So it's fabricated documents. We have already said. That is why your lordship can consider this as judgment, interim order relief also given on date 22/12, phase number 1 and 4, my lord. This is the relevant judgment already learned court of civil judge. Then relief as per
Mr. I forgot your name.
B. Hussain.
B. Hussain.
Bilal Hussain.
Yes, Mr. Bilal Hussain. Why you approach the civil court? You have already sold the property.
No, never sold. That is why I am waiting.
That is also your stand.
No, he is not the owner. I have not sold. There is a agreement, Bogas agreement, only Kasa agreement.
Okay.
No registered agreement. Why he have only entered in agreement to sell a party. It is system. Suit is barred.
Okay, no.
Its will is also not.
Bank issued notice to you.
No. Bank issued claiming that if fictitious Alauddin has obtained a loan, I have completely denied.
No. Why you have approached the bank? Why you have approached the civil court?
Particulars on that alleged claim of Bank of Baroda, Sep Manager first fabricated, and this mortgage and allegation.
Ultimately, what
declared regular null and void.
My lord.
So,
No, just a minute.
My lord, may I kindly, my lord?
Just a minute.
Yes.
paragraph 12 is relevant, my lord. Decision that the Bank of Baroda versus Ranjan Satya regarding.
No, this order is not complete.
No, my lord, the order.
Where is page 119?
119 is there, my lord.
119.
My lord,
119 is
it
missing.
starts at page 114, my lord.
No, what is 119?
119 is there, my lord.
Read.
Yes, my
It
lord.
is there in your copy. It is not there in court's record.
Yes, I'll read that, my lord. In such situation, the balance of convenience will also lie.
What ultimately was directed?
Here, my lord.
Read that portion.
Oh, my lord.
Read that portion.
Yes, ma'am. Therefore, an ex parte interim injunction at this stage is hereby issued, restraining the OP from taking any coercive action in respect of taking possession of the suit land or flat, at least till the next date. When
That suit land is same.
Suit land is same, my lord, but the problem is, my
And
lord,
flat is also same.
that is same, my lord. My lord, may I kindly, my lord. Now I am committing, my lord. My friend, my
No,
senior.
answer to my query.
Yes, my lord.
The flat which is referred to in this order at page 119
Yes.
is your flat.
No, my lord.
It is a different flat.
That injunction has been taken only for the suit land, that is the Schedule A property.
But it mentions about flat.
No, my lord. Or flat, that flat is not mine. Because I am not a party to that suit, which Mr. Alauddin had filed, which my senior friend was referring to. This flat is not my flat. Nowhere there is utterance about the Schedule B property in here, my lord. Tomorrow, if the bank claims stake over my property, I cannot do anything, my lord, because they have taken the entire, as per their notice, my lord. Notice is also there. It's a part of the records.
Okay.
That is the problem, my lord.
Okay. Heard Mr. P.R. Sharma, learned counsel for the appellant. Also heard Mr. B. Hussain, appearing for respondent number 2. How many respondents are there?
3, my lord.
Who is for 1?
1 is, my lord, Alauddin only.
No.
AM comes.
I am Alauddin is too specific. I'm not for 1.
Okay, my lord. Otherwise, AM construction was represented by Alauddin only. Page 3, my lord, of the appeal petition.
I'm for respondent number 2 only.
Whether notice has been served on A.
Yes, my lord, it has been. That is also there, my lord, at page number 167, my lord.
Appearing for respondent number 2, लिख लेना. Learned counsel for the appellant has submitted that the appellant has served the notice upon respondent number 3 by Dasti mode, and in compliance thereof has submitted an affidavit wherein the copy of notice in which the sign and seal of the respondent number 3 is there has been annexed. In view of the averment made in the, where is the affidavit in compliance, page number?
My lord, page 166 it starts. To everyone, it has been served, my lord, all the responses.
In view of the affidavit in compliance submitted by the appellant, and after perusal of the copy of notice wherein seal and signature of the recipient on behalf of respondent number 3 is there, the notice is held to be duly served on respondent number 3. Who has received notice for respondent number 1?
My lord,
Rao.
Mr. Alaudin only, my lord. It is at page 167, my lord. My lord may see the signatures also, same 167, 168 page numbers. Same person, my lord. AM Constructions, because when we had entered into that agreement, we had entered into that as with the partners of AM Construction, who is represented by Mr. Alaudin. That is why we have made.
It also appears that the notices were also duly served on respondent number 2 and 1.
He cannot take the harassment. Harassment, he cannot write. He cannot write with his right hand.
The notices are held to be, therefore held to be duly served. Respondent number 2. You are appearing for respondent number?
2 only.
Respondent number 2 submits that the respondent number 2 would be filing written objection against the contentions taken by the present appellant in the memo of appeal and seeks some time for filing the written objection. You have received the memo of appeal?
Only on telephone, he's a paralyzed in this.
No, have you?
It is with him, my lord.
Okay.
Copy received.
Copy received. The prayer is allowed. However, learned counsel for the appellant, respondent number 2, submits that he does not have any objection if in the meanwhile an interim relief is granted to the appellant, as he submits that the respondent number 2 has also filed a title suit, which has been registered
486 of 20.
as TS number 486/2025, wherein he has also filed an application under Order 39 rules, Rule 1 and 2 of the CPC, seeking temporary injunction against the bank. He further submits that the respondent number 2 has never mortgaged the suit property, that is, mortgage. You are owner of Schedule A. Schedule A in both cases same.
Yes,
They are the
Mortgage.
owner of the property. From there, we have brought our Schedule B. property.
One flat, my lord, is in the upper floor.
I am saying one flat only. When have I said 10 flats? At the-
No, maintain
My
decorum.
lord, from that time, my.
No, you have to maintain decorum at all costs.
Yes,
Otherwise, I will dismiss it.
yes. Sorry, my lord, sorry.
This is the best threat which I can give it to you.
Yes, yes.
Calendar. So property that is Schedule A land of the plaint filed in title suit number 486/2025. He submits that the Schedule A land in suit filed by the respondent number 2 as well as present appellant as well as the suit filed by the present appellant, that is title suit number 147/2026, are identical. Schedule A land.
Schedule A land is identical. So
Yes,
not identical.
I'm speaking about Schedule A land.
Yes, sorry.
Schedule A land are identical. He submits that by order dated 22/12/2025, the respondent by order dated 22/12/2025 passed in Ms. J case number 1227/2025 in connection with title suit number 486/2025. The Court of London, Civil Justice Senior Division number 3 had granted temporary injunction, had granted ex parte ad interim injunction restraining the bank from taking any coercive action in respect of the suit land within bracket Schedule A land or flat. Stop. On the other hand, no, learned counsel for the respondent number 2 has also submitted that the Schedule A land has never been mortgaged by him to any bank, and the bank has committed forgery in
Loan documents, mortgage documents.
in granting, in claiming that a purported loan has been granted in the name of one
Dictator Salahuddin.
Alauddin, which, according to learned counsel for the respondent number 2, is not the respondent number 2. Stop. On the other hand, learned counsel for the appellant submits that the appellant has purchased the schedule, appellant has purchased the flat more particularly decided and described in Schedule B of the plaint filed in title suit number 147/2026. He submits that the said flat within bracket Schedule B is situated over a plot of land fully described in Schedule A. He further submits that that the present appellant had purchased the aforesaid flat within bracket schedule B flat from respondent number 2 when
2011.
you are for bank. What is your stand?
As per their record, they have not purchased the land yet. They have agreed to purchase the land, so
Full payment done.
their title was not transferred yet. So therefore, in DRT, DRT has not considered their in surface yet.
Prayer has been made, my lord, payment has been made, my lord. Possession we are since 2019.
You are filing a written objection in this.
Yes.
Till date, my lord, I may get some protection.
की लिखी ले last line. Purchase
My lord, 2011, we had entered
in the year 2011.
had entered into the agreement. Thereafter, we had made full payment to the respondent number 2 allowed.
However, he fairly submits that though full consideration amount of the aforesaid purchase has been paid to respondent number 2,
Sale date has not.
however, no sale deed is yet registered by respondent number 2 in favor of the present appellant.
Also in physical possession since 2019.
He further submits that the present appellant is in physical possession over the suit flat within bracket Schedule B property since 2019.
Prior to the giving of the purported loan, which they are in dispute.
What is the loan, my lord? Again, I'm objecting that way. There is no question of any loan, my lord. That's why I may be permitted to file to file affidavit opposition. There is no question of this false affidavit loan, false mortgage.
I have reflected your submission. Learned counsel for the appellant has further submitted that since has further submitted that the appellant had also approached DRT.
Yes, my lord. No
Had
protection has been given.
also approached DRT, Debt Recovery Tribunal.
At page number 128, my lord, order is there. Notice has been issued, but stay has not been given regarding the Schedule B property. I've appended everything, my lord. 128, my lord. 1 to 8, my lord. The order starts, my lord, the DRT order. The case which I had filed, my lord. My respected senior, Mr. Yusakia, was also there. Same case, my lord.
Which has been registered as SA number 142/2025.
My lord, SA 180 to 18 of 26, my lord. Perhaps 18 of 26, page 128. 1 to 8.
Or SA number 18 of 2026, in which notices have been issued to the other side. However, he submits that since he has received notice under section 13, from whom you have received?
I have not, my lord, that 13-4 notice by the bank that was affixed in the property wall against Mr. Alauddin only. But Because I have a property there, my lord, so the entire property is going to be going to be in favor of the bank. Because my flat is also part of that property only, my lord. That is my grievance. That notice, my lord, would have at page 109, from where the entire controversy arises. 109. 8126, my lord. That is on.
No, since kill last line. Since the respondent number 3 within bracket bank has affixed a notice under section 13 of Surface Act on the Schedule B property, which has come to the notice of the present appellant, he apprehends that unless some interim protection is granted to him, the bank may proceed with auction sale of the suit property. He submits that the present appellant is no way involved in the purported loan for non-payment of which the actions against Surface Act is sought to be taken by the bank. Stop. On the other hand, what is your name? You Saikya, learned counsel for respondent number 3 bank, submits that the respondent number 3 may be granted some time for filing written objection in this appeal. You filed written objection. I am not reflecting anything now. We are directing the parties to maintain status quo in this. Stop. Let this matter be listed again on 4th of May, on which date both the respondent number 2 and 3 may file their written objection. However, considering the submissions made by learned counsels for the appellant as well as the respondent, as discussed in the foregoing paragraphs, the bank, that is respondent number 3, is directed to maintain status quo in respect of Schedule B property till next date fixed. List accordingly on.
That may be it's not that maybe because Surface proceeding is going on in the DRT itself. So after vacation on the DOB.
It will go in May. Otherwise also it will go in May. 4th May.
I'm so obliged, my lord. I also apologize for losing my cool.
No, you have to maintain.
I'm so sorry.
Because even if you have merited.
Apply from them, my lord. Apply from them, my lord. So.
The earlier date will remain.
8/5, my lord. Earlier it was 8/5, then subsequently it was changed to 7/4.
On 7/4, you have any difficulty?
No, my only difficulty is that, my lord, I have not received all the papers from my client, my lord. So on that day also I'll have to take time only, my lord.
Okay.
So let it be on 7/4 then, my lord. I will pray for adjournment.
Okay. On 7/4. Kunal was Abhishek. It will be on 7th.